Somebody was talking about it the other night. Saying something about it, they want to sign up for it. Somebody was there, but I think they left. Yeah, they're good. As far as I know.
You've got elected officials, planning board, board of adjustment members, historic resources commission members, attorneys, staff members. So we've got a little bit of everybody here today. I see that everybody's found the food table. In case you don't know where it is, exit this door, turn to your right, and you can find the refreshments. Should you need to go to the restroom, exit this door here, go out to the main hallway, take a right, and then an immediate left, and you'll see a 4-door. Those restrooms are open. Okay? If you did not receive a parking validation, please go to the table outside the store again, and we'll get one of those for you. If you park in the garage here at, next to 200 College Street, it will get you out of the garage for no fee. We've got a really tight schedule today, and we're going to have to stick to our agenda pretty closely. David Owens will make some adjustments as necessary. If you have a topic that you'd like a little more information on, I'll let him go into detail on that. Most importantly, I wanted to give a quick introduction for Professor Owens. We're super ecstatic to have him here today. This was a custom training event, and it took a lot of time and effort to pull together. David Owens joined the Institute of Government in 1989. Prior to that, he was an attorney and senior planner for the Wisconsin State Planning Office and spent 10 years with the North Carolina Division of Coastal Management. His publications include numerous books and articles on zoning law, including basic, legal reference, land use law in North Carolina, and widely used guides for citizen boards. It's called The Introduction to Zoning. He's also written on a variety of land use law topics, variances, special use permits, extraterritorial jurisdiction, the scope of local government authority, urban growth management, regulation of religious land uses and adult businesses, conflicts of interest, planning legislation, and various aspects of coastal management law and policy. Owens received a graduate planning degree and law degree from the University of North Carolina at Chapel Hill. I just wanted to point out also, David Owens, together with Adam Lovelady, just came out with the updated version, the Quasi-Judicial Handbook. At Buncombe County, we found this book to be exceptionally helpful with our Board of Adjustment, and I think our board chair is here, and I've actually seen him pull it out from time to time and refer to it in a board meeting. So the school government, if you're interested in this book, that is available through them. Let's give a warm round of applause to David.
All right, thank you very much. Everybody here all right? Good. Move this down a little bit so it's not quite so loud. Delighted to be here. Took my jacket off, I'm ready to go. One of the things I will do is watch our clock so that we get out for our breaks on time and end on time. We'll go about an hour, take a break, go another hour, take a second break, and then finish by 4:30. So roughly every hour we'll get a 10 or 15 minute break, and we'll go from there. The agenda for this afternoon. The main thing we're going to do is talk about quasi-judicial proceedings. What are they? When do these rules apply? How do you do the hearings? How do you make a decision? So that's what the bulk of our first 2 hours will be, is talking about quasi-judicial proceedings. Then, sort of bonus coverage, we could do all 3 hours on that, but some folks might want to break from do something a little different. And if we finish quicker than 2 hours, we'll move on into these other topics. An update on recent North Carolina legislation, including the new Chapter 160D, which is the complete reorganization and rewrite of all the state's planning and zoning statutes that go into effect in about a year from now. It's already been adopted, so we'll go over that and the highlights of the changes that are going to affect cities and counties working with that law, so we'll do that. And then lastly, talk a little bit about affordable housing, in particular incentives that local governments can do to increase the supply of affordable housing. To the extent there's anything else you would like to talk about, raise it as we go. I'll try to answer. I can answer things whether I know something about it or not. If the questions are more about land use law, there's a better chance that I'll actually know what I'm talking about and providing you a response to that. But I will try to do that. So if anything comes up that you think is related, that you want to raise, do that as we go. I know the agenda that's passed around says we'll have some time for Q&A at the end, and I'll try to leave a little bit of time in case there's just something, I thought we were going to get to this and we never got to it and I'd like to ask about it. But on the subject matter we're covering, if anything comes up that you would like to explore in a little more detail or get some clarification on, do raise that as we go, and we'll still manage to watch our time and finish when we need to finish. I think it's important that you do that because we've got, 6, 7 different jurisdictions here today, and occasionally there are things you might be doing in local practices that are useful, innovative ways of addressing a vexing problem, and it's good for your peers and colleagues to hear about that and learn from each other as we discuss these issues. On occasion, you may be doing something that is totally inappropriate and illegal, and it's inconsistent with the way I described things. It's better to find that out here today, and you probably have time to correct it. And when your attorney comes to see you and says, "Did you really do that?" So raise those as we go. Everybody good with that? All right. Quasi-judicial decisions. What are they and when do these rules apply? Just very briefly, distinct land use decisions in North Carolina are divided into 3 or 4 categories, actually 3 that boards made. 3 categories of different types of decisions. And this is not an academic distinction of sort of splitting these into 3 parts. Our legislature, our statutes, our courts have put things into these categories, And it's important because there are very different rules you have to follow depending on which type of decision you are engaged in. Our rules do not vary depending on which board is making the decision. The rules are entirely based on what type of decision it is. And today we'll be talking about quasi-judicial. It doesn't matter whether you're an elected board, an appointed board, planning board, the Board of Adjustment, Historic Commission, the Housing Appeals Board. If you're doing a quasi-judicial decision, there's a set of rules that apply to that. Different set of rules for legislative decisions and for advisory decisions. A legislative decision is one that adopts, amends, or repeals the ordinance. So adopting the zoning ordinance, rezoning an individual piece of property, changing the text to add a use as a permitted use or to convert it to a special use or to change the setback standards. All of those are legislative decisions, and the rules are almost entirely set by our legislature, and they're almost all related to process, to make sure there's broad public notice, an opportunity to comment, and a thoughtful decision, but a huge amount of discretion left with the local elected officials to decide what the rule ought to be. But you can't change your zoning ordinance without holding a public hearing on the change, sending it to the planning board for review and comment. If it's a zoning map amendment, you have to mail a notice of the hearing to the adjacent property owners, and so forth. So the rules are there for legislative decisions to make sure that the public's aware of and knows what's going on and can comment on it and offer you their advice as to whether it's the right thing to do for your jurisdiction or not. And for the most part, the courts don't get involved in looking at the substance of that decision, with a few modest exceptions. The general rule is it's up to the good judgment and discretion of elected officials, and if the citizenry thinks you're being too strict in your zoning regulations or not strict enough, the remedy's at the ballot box, and you throw the bums out and elect a new set of folks to do a different set of policies at the next election. That's the sort of legislative arena. The other end of that spectrum are ministerial or administrative decisions, which are typically made by staff, where you're implementing the ordinance and applying objective standards. Is this use permitted in this district? Does it meet our height limit? Do they have the right kind of buffer? There's no public hearing. It's simply assigned to staff. They make their decision. And if somebody doesn't like it, they can appeal to the Board of Adjustment and on to courts later on. Key there is that opposite of legislative, where there's extremely broad discretion on the part of the governing board, staff has virtually no discretion. Very, very limited discretion. You're applying objective standards and implementing terms of the ordinance. What we're dealing with today is the middle ground between administrative and legislative, which are quasi-judicial in the nature of, similar to a judicial proceeding, but a little less formal than a courtroom proceeding. Key thing is that you're implementing standards that are already in the ordinance. You're not setting new policy when you're applying these, making these decisions. You're applying standards that are either already in the state statute or in the ordinance. When you hold a hearing on a quasi-judicial matter, we'll spend a lot of time on this, the purpose of the hearing is not to solicit public comment as to the desirability of the project. That's almost always totally irrelevant in a quasi-judicial matter. You don't hold, in a legislative matter, should we change our zoning ordinance to allow residential uses above commercial in downtown? Policy choice. You hold your hearing, people come and tell you, is that a good idea or a bad idea? Should we do it? What should the limits on that be? If it's a special use permit for that, the question is not, should we allow this? The question is, does this particular application at this site meet the standards in the ordinance? You're not making up new policies. You're applying the policies in the regulation to a specific application. And the only reason you do a hearing is to gather evidence as to what the facts of the case are, not to solicit opinion about whether it's desirable or not. That's an absolutely critical distinction between legislative and quasi-judicial. You have some discretion, but limited discretion. Your purpose, you have two key responsibilities. Any board making quasi-judicial decisions, two key things you have to do. What are the facts of the case? Particularly if there's an argument about it, if the facts are contested. Will this have a significant adverse impact on neighboring property values? Well, what are the impacts? What's the evidence to support whether it will or it won't? So your first job is figuring out what are the facts of the case, much like a jury would in a judicial proceeding. And then secondly, to apply the standards that you've got in your ordinance, in the statute, to that particular set of facts. Those are your two main jobs in a quasi-judicial matter. Basically, your only two jobs. You don't get to decide what the standards are, and you don't base your decision based on what a majority of the folks showing up at the hearing would like to do. I say that because that is the greatest temptation that folks run into. I talk to boards around the state and they say, well, I got appointed to exercise my good judgment. We've got a project that looks like it meets the standards, but it's a loser. And we got a room full of citizens out here who are adamantly opposed to this, good, hard-working, tax-paying citizens who think this is just awful. I think it's just awful. And surely I have some discretion here as a public officer to be able to stop this kind of mess from happening. No, you don't. Your job is to apply the ordinance that you've got and to find whether or not it meets the standards. If it meets the standards, whether you like the project, whether the neighbors like the project is irrelevant. If it meets the standards, the person has a legal right to their approval. Similarly, if it doesn't meet the standards, even though you think it might be a good idea, if somebody comes in and applies for a variance, and they clearly do not meet the legal standards for a variance, but you think, well, what's the harm? We don't allow this sort of thing. No. You have no response. And the reason is not because the legislatures and courts think you don't have good judgment or that you're crooked or that you're somehow bad. The notion is if you want to change the rules, you need to go through the legislative process. It's a whole different avenue to change the rules, to make them better, to make them fit in your objectives and do what you want to do. And a quasi-judicial decision is simply not the right venue for doing that. You don't have the same kind of public notice, planning board review, public hearing, opportunity for comment, and so forth. It's a different process to change the rules than it is to apply the rules and exercise some limited discretion. But what makes it quasi-judicial is that some of the standards you're applying involve judgment and discretion. So yes, you're applying the standards, but would it have an unnecessary hardship? Well, how much hardship do you have to have before it's unnecessary? A significant adverse impact on neighboring property. Well, how much of an impact, negative impact, does it have to be significant? There's judgment you have to exercise, but it's limited discretion. It's within the bounds of the terms of the ordinance.
We're speaking here in purely government terms. Our group also has to apply national standards set by professional groups as well.
What kind of ordinance are we talking about? Where there are national standards?
Well,
Historic
resources and standards that have been set for preservation of historic structures and things like that. Kind,
Sure.
Which are set not here in Buckingham County, but on a national basis.
Yes and no. let me hold, I'll get to, well, I've got a slide of about 4 slides down the road, and I'll speak to that in a little more detail before I jump into that. Anything else basic on this basic distinction, though? I mean, one of the questions is what standards do you apply, and how do you know what those are, and then what evidence do you get to do them? So that's an absolutely critical part of all of this. My sort of last introductory general point is this notion of due process, without getting overly legalistic about it. But that's the foundation of why there are very stringent rules about how you make quasi-judicial decisions. Remember I said earlier, with a quasi-judicial thing, if somebody shows they meet the standards, they're entitled to the permit. That's critically important. In a legislative matter, if I apply for a rezoning, I have no legal right to that rezoning. There's no property right to that rezoning. The city council, the county commissioners can decide, you make a good case, nice idea, but no, we're not going that direction. And I can't sue the city council or county commission and say, well, that's a bad decision. I ought to be able to allow to do this. I've made a good case. Give me. It's a discretionary decision, and the elected officials decide whether or not to approve the rezoning or not. Very different with quasi-judicial. If I produce the evidence as the applicant to show you I meet the standards, I am legally entitled to my approval. And the courts have said that is a property right. I have a property right in the approval. And if you're going to deprive me of that property right by denying my approval, you have to exercise due process of law before you can deprive me of a property right. And since I have a property right, due process kicks in, and our courts have said that includes, when you're doing that, due process requires a long list of things. Clear guidance, standards, notice, opportunity to be heard, impartial decision makers, decision based on the record, and so forth. All those rights kick in there. They're put in the statutes now, but this all flows from how our courts have interpreted what the due process clause requires whenever you're making these kind of adjudications.
Could you speak just quickly on if the applicant, they're presenting evidence, do you assume that they present evidence? Is it the majority of evidence? Is it evidence beyond a reasonable doubt? Or
We'll talk about that at some great length in just a few minutes. My last thing before getting into evidence, and that's the next sort of whole segment, is conducting your hearing to collect evidence. And I mention this because it is sometimes a sensitive topic, and I want to bring it up while we're still fresh. One of the due process rights you have when somebody's making a quasi-judicial decision is the right to an impartial decision maker. You do not have that right in a legislative context. You can go in and say, I think we need more multifamily housing in our jurisdiction. And you have a council member that says, I ran for city council because we got too many multifamily housing projects, and my policy position was prohibiting any more multifamily housing, particularly if it's adjacent to a single-family residential neighborhood. Well, you can't say, well, you shouldn't vote on my rezoning or my text amendment because you're biased. You've already taken a position about whether we need more multifamily housing. A bias in a legislative context doesn't matter. We call those biases campaign positions and policy directions. And you elect folks, as long as it's not discrimination on the basis of race, sex, religion, etc. Those kinds of policy positions are perfectly legitimate and fine in a legislative context. Not fine in a quasi-judicial context, because one of the due process rights the parties have is the right to an impartial decision maker. Which means if you have a bias, a fixed opinion that is not susceptible to change, you must not participate. So if there's a special use permit for a multifamily housing project and you have an interview with the press the day before the hearing and say, I don't know what they're saying at this hearing tomorrow, but I got appointed to this board to prevent this kind of mess from happening in our community, and by God, I don't know what they're going to say tomorrow night, but I'm voting against that sucker. It's perfectly legal for you to say that, but you've just disqualified yourself from any participation in the hearing or the vote on the matter because you've expressed a fixed opinion about the outcome of the case before you've heard the facts and the merits of the case. So the parties have a right to no bias, no conflict of interest. If you have a financial interest in the outcome of the case, you must not participate. If you have a close family, business, or associational relationship with a party to the case, you must not participate. Not because, the question is that can I set aside the fact that it's my brother who's applying for this permit? The court says if a reasonable person would have grounds to wonder whether your decision is based on the merits of the case or your relationship with the party, you must not participate. The question isn't whether you can set those feelings aside. The question is, would a reasonable person have grounds to wonder whether your decision is based on the merits of the case or your relationship with the party? I had a board of adjustment doing in a small town, and it turned out I gave that example, and they said, well, wait a minute. We were just looking at a variance for a rear yard setback for a church. Sure. They're doing a new education building. Needed a rear yard variance for their rear yard setback. But the guy asked me questions, but I'm a member of the church. Does that mean I can't vote? Well, I want to be kind of, I didn't want to offend guys. I said, well, you know, maybe if it's one of these 3,000 member churches and you attend once every other year and they slap a visitor's tag on you when you come in, you know, maybe it's okay. But, oh, no, I was the chair of the church building committee. Well, you know, if you're the neighbor who has some concern about this variance, you might have reason to wonder whether that member's vote is based on their role with the church or their role as a member of the Board of Adjustment. And if there's a reasonable grounds to have that doubt, don't participate. And sort of the last thing is not really a conflict of interest, but it goes to impartiality, is outside communications are prohibited. One of the legal rights a party has is to hear all of the evidence that is going to be used to decide their case. If you're meeting with the applicant to talk about the case outside the hearing, you're gathering information that the other side doesn't hear. They don't know what that person's saying. They don't have an opportunity to cross-examine that or to rebut that evidence. So you're not allowed to gather any evidence outside the hearing in order to protect the rights of those who are affected by that decision to see and hear all of the information being made available to you. So that's just one of the other rules of ensuring impartiality when you get to these cases. Any questions, thoughts about that before we leave conflicts and impartiality? My suggestion is not a legal requirement, but my suggestion to you is that it's a good practice to have a sort of script when you're doing a quasi-judicial hearing at the beginning to explain to the applicant, to the folks who are there, the nature of these hearings and how it's different from a legislative and that you're taking a formally acquiring evidence, etc. But also to ask each of the board members before you start, does anybody here have a close family, business, or association relationship with a party? Or any other conflict, or if you had outside communication about this case that you need to disclose. And I say it's best to do that at the beginning, because if you have a conflict, the solution is not abstaining from voting. If you've got a conflict, you must not participate in the decision at all, which includes asking questions during the hearing, participating in discussion or deliberation about the case. The courts have said that if a member with a conflict is participating in the discussion, that taints the process and invalidates the decision, even if that member ultimately abstains or their vote was not necessary for the outcome of the case. So if you've got a conflict, you don't participate at all. And in order to prevent somebody from inadvertently participating, it's good to ask that up front at the very beginning of the hearing, so that if anybody does need to be excused, you clearly get that done up front before you start down the path of hearing evidence and discussing the case. All right. I'm going to speed through this next section exceptionally fast. So this is where if you got a question, raise it. Otherwise, I'm moving on. And that is to just say, one of the questions that we had a little bit earlier was, well, what standards do we need to apply? Each different type of decision will have a different set of standards. If you're dealing with a variance, which is probably the single most common type of quasi-judicial decision, almost always assigned to the Board of Adjustment, but it can be assigned to the planning board or other body. The standards for a variance are set by state law, not by your ordinance. Our state statutes in North Carolina for both cities and counties say these are the 4 standards for a variance. If you meet those standards, you get your variance. If you don't meet those standards, you should not. Unnecessary hardship would result from a strict application of the rule. The fact that I don't want to comply, that I would prefer not to comply, that it would be cheaper to do it a different way. No. Unnecessary hardship. Some hardship is necessary. It's going to cost me more to follow the rules. The law assumes there is some hardship. The question is it an unnecessary hardship? It's a hardship that is significant, that is imposing a burden, that isn't really serving in a legitimate public purpose. So unnecessary hardship. The hardship has to result from conditions on the site, not the personal circumstances of the applicant. I'd love to comply, but there have been hard times lately, and I really can't afford that. I'm sorry. I hate to be hard-hearted, but your personal circumstances do not justify a variance. A variance has to relate to the property itself, not the personal circumstances of the applicant. There's one important exception to this that does not exist in the current law. It should, but it doesn't. And it will. It's added by Chapter 160D, which goes into effect in a year. And that is, under the Federal Fair Housing Act, you need to make a reasonable accommodation for a person with a disability. And that is a personal circumstance. It is not grounds for a variance under our current statutes. The new law will say that is one of the exceptions to this rule, is that if you need to make a reasonable accommodation for a person with a disability, that is a situation where you can grant a variance. Third standard is that it not be a self-created hardship, not result from, I hired a contractor, I thought they knew what they were doing, they poured the foundation, we discovered 2 weeks later they threw the line from the wrong stake, and the foundation is sitting 5 feet into the side yard. It's going to cost us a lot to move this. If they created the problem through their own negligence, that's not grounds for granting a variance. And then lastly, and most importantly, is the variance consistent with the spirit, purpose, and intent of the ordinance? If we gave you this approval, will we still accomplish the purposes and reason we have this rule in the first place, which is always something you should be thinking about with a variance. So those are the standards you're applying for a variance. So when you do a variance hearing, you're gathering evidence to see whether or not they meet those standards. When you switch over to a special use permit, also in some ordinances called a conditional use permit or a special exception, the standards are set by your own ordinance, not by state statute. So you have to look at your ordinance and say, what are the standards for this particular type of special use permit in our jurisdiction? The 4 standards I put on the slide are ones that our courts have said are adequate, and my seat of the pants estimate is about 90% of the jurisdictions in the state use some variation of these 4 standards. Would it materially endanger public health and safety? Does it meet all required conditions of the ordinance? Would it substantially or significantly harm the neighboring property values? And would it be in harmony with the surrounding area, compatible with surrounding land uses? So harmony and compatibility with the neighborhood, property value impacts, public safety, which about 90% of the time is a traffic issue. We call it a traffic safety issue. Those are the kind of standards that you have. You may also have specific standards for certain special use permits that, in addition to these four, if it's a telecommunication tower, it must have an adequate fall zone, adequate fencing, various other odds and ends. So you can add more detailed standards for particular special uses. But again, you have to look at your own ordinance and see what the standards are. I think it's a good idea, not required by the statute. Another sort of, my suggestion is a good idea is, in addition to telling people about the rules of the game, I think it's always good at the beginning of a hearing to remind the applicant and the board members, we're looking today at whether this project meets the following four standards. So the evidence you present as a witness needs to relate to these four standards. Board members, when you're making a decision, need to be thinking about whether it meets these four standards, six standards, whatever it might be. I told you I'd get to this. Certificates of appropriateness. A historic commission, before you do alterations, exterior alterations, you demolish, alter, build new construction in a designated historic district, or making changes to a designated landmark, you have to get a certificate of appropriateness. This gets a little more complicated. Boards, historic commissions are different from other quasi-judicial boards, and it's the only board where there is a mandate by statute that certain expertise be present on the board. The board has to have folks who know something about construction and historic standards and the like. But the key question is congruity of the project with the guidelines for that particular district. I'm talking about historic districts. The new statute is going to change the word guidelines to standards to make it clear that these are mandatory standards. But before you designate a historic district, you do a study and you determine what the character of the district is, what makes it special. And the question with an individual certificate of appropriateness is, how does this project fit or not fit within the guidelines for this particular district? No, it's not a national standard that you're applying. It's what's in your own guidelines for that district. Now, those guidelines may have gone through the State Historic Preservation Office. You may be using some national standards to do that in terms of, we've researched what are the appropriate architectural styles and color and scale of buildings for a neighborhood of principally Queen Anne structures or whatnot. But those are the standards you're applying. The guidelines for that individual district as opposed to a national standard. Personal opinions, even though the members of the board have expertise, it's not a question of, well, I think this, I like this, or I don't like that. Town of Beaufort. Beaufort? Not Beaufort in South Carolina, but Beaufort in North Carolina has a very active historic district. A lot of concern about the historic character of the district. Somebody had a vacant lot and wanted to put a building on it. And a dispute arose as to the height of the building and whether it met the historic district guidelines. So having the chair or one of the key members of the historic commission lived in the house directly across the street and had a view out over this lot of the harbor. And this house was going to affect that view. And so there was a lot of debate on the historic commission of should it be a story and a half, 2 stories, how to measure a story, should it be 23 feet or 26 feet? I mean, they were cutting some fine lines there. And ultimately, the town lost. I mean, they issued a permit, but they imposed conditions on it. And they lost in court because when it got to the court looking, it said, well, you just had a bunch of people debating about what they thought the appropriate height of that structure should be and how it affected views. And it's not the personal opinions of the board members that matters. It's whether or not this project as proposed met the standards, the guidelines for that district, and the predominant height of structures and the character and so forth. You got to tie it to those guidelines, not your personal judgment as to what the right answer ought to be. So that gets to sort of applying the rules in the ordinance rather than your personal opinions, even when you're doing a technical consideration like a certificate of appropriateness in a historic district. Am I good with that? Appeals? Yeah.
Question on that. And seeing those apply on certificates of appropriateness,
Yes.
they seem to be really technical and almost checklist in nature. Do you run into an issue or a potential challenge that it's actually an administrative decision and not a quasi-judicial decision?
It can. I mean, sometimes they are. I mean, if the ordinance, people argue a lot about materials. You know, what do you mean you want a vinyl window in our historic district? That's not the right kind of material. And sometimes you have it will include some objective standards. Materials, a color palette, architectural styles, ornamentation, and so forth. And when you're applying those are objective. And if you had only objective propositions, then you could make it administrative. But most of the guidelines also have some more general element of character and allow a little more leeway and some judgments involved in applying those standards. And if you've got any element of discretion, then that's what kicks it over into quasi-judicial. And the new statute just says, blanket, all certificates of appropriateness of quasi-judicial decisions.
What about historic structures that aren't in a historic district?
Are they designated landmarks?
Right, and doesn't have standards. It's a standalone.
In designating that landmark, there should be some standards in terms of what it is that makes it historic and what are the essential elements of the character of that landmark, and that's what you'd be looking at, some of the equivalent of that. But it's going to be structure specific rather than, and remember, structure also includes the grounds and fencing and area right around the structure itself. All right. We're 1:20. We'll take a break in about 25 minutes. What we want to do next is talk about running your hearing. One of the things I think this new statute does that's very helpful is gets away from the language of calling these public hearings. All of your hearings are public hearings. They're open to the public and people can sit there and watch them. Well, there's a big difference between a legislative hearing and an evidentiary hearing. A legislative hearing is when the kind of public hearing you're having to make a legislative decision. Anybody can show up and say whatever they want. You can hold them to 2 or 3 minutes, but if you've been to many zoning hearings, you recognize that folks will say some things that, what? But that's perfectly legit. You're asking folks for their opinions. They can opine about the wisdom and desirability of the legislative action. In a quasi-judicial matter, you're doing an evidentiary hearing. A hearing to gather evidence. That's the only reason you're holding a hearing. Not to solicit public comment, to gather evidence about the case. Because one of the rights parties have is that the decision must be based on competent, material, and substantial evidence in the record. That's the legal standard. Before you make a decision, you must have competent, material, substantial evidence in the record to support the conclusion you make. I don't have a hard and fast statistic, but I would say overwhelmingly, like 90%, of the time you lose in court on a quasi-judicial matter, it's because you don't have sufficient evidence to justify the decision you have made. When you go to court on a quasi-judicial matter, the court does not hold a new hearing. They do not gather any additional evidence. The court is sitting there as an appeals body, and the first thing the court is going to say is, did you have sufficient evidence in the record to justify the factual findings you made? So you denied the permit because you thought it would have a substantial adverse impact on neighboring property values. The judge says, okay, I'm ready. I got the hearing record in front of me. What page do I look at to find the evidence on substantial adverse impact? I'm listening. And if the answer is, well, there really wasn't much evidence, but it was clear to us as board members that this would be a terrible thing. At best, you're going to get it remanded, and more likely, you're going to lose. You most often lose not because the judge disagrees with how you weighed the evidence, but because there simply isn't evidence there to support the conclusion you reached. And it has to be quality evidence because you're affecting the rights of those parties. I have a legal right to my permit if I meet the standards. You're affecting my rights. If you're going to deny that or impose conditions, you've got to have some real evidence to support that decision. And the real evidence is it's trustworthy, it's reliable, and it's sufficient to reach that conclusion. That's what substantial evidence means. A reasonable person would come to that conclusion based on this set of facts. The initial evidence, the application and the staff note. We'll talk a little bit when we get to the decision. The burden is on the applicant, not the staff. Who has to present the evidence? Easy answer, the applicant. It's the applicant's job to bring you sufficient evidence to show they meet the standards required to be approved. Not the staff's job, not the board's job, it's the applicant's job. If you conclude there's just not enough evidence to show you meet the standards, then you deny the approval. Or you continue and say, you need to do a better job of this, we're going to come back next month, bring us a little better evidentiary support for your conclusion. But the burden is on the applicant. Your application forms are designed to solicit that kind of information. If you've got a good application form that says, tell us how this is an unnecessary hardship. Tell us how it's consistent with the spirit, purpose, and intent of our ordinance. Show us, the application is usually based on the standards you've got to meet and designed to solicit the kind of information. So you get that application is then presented and becomes part of your hearing record. You also have, almost always, a good, capable, professional staff. And a lot of times you ask your staff to do an analysis of this and prepare a staff report. And that's also evidence that you're going to consider. So you want your staff report to go through the details, do some analysis, put that in writing, and give it to you as part of the record. Very importantly, both the applicant or whoever puts together the application for the applicant and the staff member also needs to be present at your hearing to present that staff report, to present that application, and to answer any questions you've got about it. They can testify about it. We'll talk about hearsay and ex parte out later, but generally they do that. They're under oath, subject to cross-examination, and they explain what they've given to you in writing. Site visit. How many of you actually go out and look at the site before you do a quasi-judicial matter? Some people are going, is it legal? Can I do this before I raise my hand very high? As a general rule, as a board member, you should not be gathering evidence about the case prior to the hearing. Do not go on the internet and start searching for information about this case. Do not go poll the neighbors and ask them about stuff. But the site you can't bring into the hearing. I mean, some people will do a video of the site, the photographs, but sometimes there's no substitute for just driving by and looking at it and taking a look. That is perfectly okay, provided when you get to the hearing, you tell people, I went by and looked at the site. I would disclose that at the hearing, that if you've done that, tell folks you've done that. And if there's something you saw that you think is relevant to the decision, that influences how you're going to vote on this, you need to say so out loud at the time. I drove by there last week and there were 6 inches of standing water sitting on the west side of the site. If you see that and that influences your decision, you need to say so out loud, because then pretty much, wait a minute, that's 2 doors down, you're looking at the wrong site. They have a chance to rebut that evidence, to explain it. So if it's influencing your decision, lay it out at the site. And you can ask questions about it. I looked at this, I saw the property next door, looks like it was such and such, I don't see that in the pictures. Can you explain how this would relate to that? Or, there's a huge traffic jam. It looked like we need a turn lane here. Can you explain traffic counts and how that relates to ingress and egress to the site? But if you see something important there, lay it out at the hearing. Preferably at the beginning of the hearing, not wait until you get into the deliberation and getting ready to vote. Because one of the rights you're trying to protect is the right of the applicant and the neighbors who are affected by that decision to know the evidence and to be able to rebut it if they disagree with it. So you need to lay it out in a timely fashion so that folks can do that if need be. The testimony you get, when you have a hearing, people are speaking. They're not just standing up and saying whatever's on their mind. They are testifying. In order to get competent testimony, you want the witness to be under oath. That's useful in a legislative matter. Some degree of exaggeration is part of the grand American tradition. If you allow this thing, it'll be the worst thing that ever happened. The ruination of civilization as we know it. I wouldn't go to sell my house for a nickel if this was across the street. In a legislative context, that sort of hyperbole is to some degree accepted. It is not in a quasi-judicial matter. And putting folks under oath who are offering you testimony is a reminder to them that they are to tell the truth, the whole truth, and nothing but the truth. It's a solemn proposition to remind them of the nature of this kind of proceeding. And it also helps you have competent evidence. One, you cannot make a critical finding of fact on a disputed fact based on unsworn testimony. So if all you've got is unsworn testimony, you cannot use that to make an important finding of fact. It's also kind of awkward if somebody gets halfway through their testimony and you say, well, wait a minute, I think we probably need to get this witness under oath. People could take offense if you raise that halfway through their testimony. So as a practice, you need to be doing this to everybody all the time at the beginning. You can swear people in as each individual witness does. Some people have to say, sign up if you're going to be testifying tonight, and the clerk will swear you in. Prior to that, to save time, you can have everybody that's testifying come down at one time, and it looks like a football hub. You have 8 people getting sworn in at one time. That's perfectly fine. You should, if you do that, you should remind each witness as they start, verify that they did take an oath, remind them they're under oath, but that's perfectly fine. But you want to get that testimony under oath. You want to remind people to testify about the facts, their opinion. We'll get to expert testimony in a minute, but unless they're an expert witness testifying about these matters, their opinion doesn't matter. You want facts that they know about. firsthand knowledge. I live across the street and I've seen X, Y, and Z. That's the kind of evidence you need. Personal opinion, unsworn. Again, lack of evidence is where you lose. And particularly, the classic case, and in the last 2 or 3 years there have been 7 or 8 cases at the Court of Appeals that the board loses on special use permits. A lot of them involving solar farms. We did a classic sort of solar farm application for a special use permit. The applicant has a detailed scientific report. They bring in an appraiser who's going to talk about the impact on, offer an expert opinion on property value impacts. They've got an engineer on all the specs. They've got a stormwater engineer. All that's laid out. Then you get a room full of citizens who say, this is awful. We don't like it. Everybody knows if you put a solar farm next door, it's going to ruin my property values. Or you put this multifamily next door, it's going to be crime, disease, whatever. The court looks at it and says, if you're basing your decision on unsubstantiated fear, you lose. You've got to have facts. So if the neighbors are, and it does put the neighbors at a disadvantage. You've got an applicant who's a professional at this, who has some money, who's hired the right professional, and your heart goes out sometimes to the neighbors who are unprepared. They've never been to a zoning hearing before. All of a sudden you got this fairly formal process with witnesses, and they're just legitimately very concerned about the impacts of this on their neighborhood. They feel very strongly about it. And what you have to sadly remind them is that the depth of your feeling doesn't help you. The sincerity of your feelings don't matter. I mean, it's cold, it's hard, but it's fact. You've got to give us some facts we can base our decision on. And the fact you really, truly, deeply feel strongly about this. And I say this because I've worked with citizens who often have the notion of that if we feel strongly enough about it, that will carry the day. In a legislative context, that might well be true. In a quasi-judicial context, it is not true. And that's where you get into trouble. Is you think they've probably got a case, you're sympathetic to their concerns, but they really haven't given you the facts to make that decision.
What's the appropriate way to prepare, residents and neighbors for that mindset?
A couple of things you can do. Handouts are always good. To give folks handouts. This is the nature of this decision, the kind of information we need. A little script at the beginning that reminds them that this is not a legislative matter. If you do a notice of the hearing, maybe attaching that flyer to the notice saying this is the kind of evidence you will need when we get to the hearing. Occasionally, if you have a hearing and you think the neighbors have some legitimate concern and they're unprepared, you always have the option of continuing the hearing. But of course, that's at a cost to the applicant. The applicant is there, they're prepared, they've got their ducks lined up, they're ready to go, saying, well, that's all well and good, but our poor uninformed neighbors are not prepared, and they just learned tonight they need this stuff. We're going to give them a month, and so come back and continue the hearing the next month and give them a chance to present their evidence. It's something you can do. You don't have to do it. And you may decide the balance of fairness to the applicant is everybody had notice. If you're prepared, fine. If you're not, we're sorry, but we're moving forward. That's a judgment the board has to make. But it'd probably be real good to assume that most of the folks appearing have no idea what a quasi-judicial hearing is and what kind of evidence they need. So some patience and explanation, I think it is essential, but a good handout, a 1 or 2 page handout that you can get to folks in advance, I think helps a whole lot. Opinion evidence. Everybody knows X. Everybody does not know X. Nobody knows X until it's established as a fact in your hearing. Our courts have said, and it's now in our statute, that in a quasi-judicial matter, you can only rely on opinion testimony from an expert witness if the issue is traffic impacts on safety, property value impacts, or other issues for which an expert witness would generally be required. The main two things are traffic impacts on safety and property value impacts. If somebody is offering you opinion testimony about property value impacts, they need to be a qualified expert witness. And in that context, you need to qualify them as an expert. They have the education and experience in that issue, and, very importantly, and have they done a proper study upon which they're going to base a professional opinion. We had a case that went to the North Carolina Supreme Court on a broadcast tower. We put a large radio broadcast tower up, and one of the issues was the property value impacts of that tower on neighboring properties. One of the witnesses for the applicant and the neighbors who opposed it had witnesses. One of them was a member of the Appraisal Institute and 30 years experience. The other, for the other side, was a real estate agent who had 40 years experience working in the community. They were both undoubtedly qualified experts. The court threw out the testimony of both witnesses because neither one had done a study that said, I have looked at properties similar, adjacent to towers similar to this, and based on that analysis of those properties, my professional opinion is X. They just came and said, I'm an expert, I know a lot about this stuff, and I think it's going to be good, or I think it's going to be bad. Even an expert witness needs to have done the study to justify their decision. A layperson, however, can give you factual testimony. I think this is going to be a traffic safety problem because I live across the street and I have personally observed 14 traffic accidents at this intersection in the last 2 years. Or I live across, one of my other favorite cases, I live across the street, you're putting multifamily down at the end of this street that's going to generate 300 trips a day. I watch every afternoon from my porch, a school bus lets 10 kids off who walk down this path with no sidewalk on a 12-foot paved right-of-way, and if you put that many cars on that, that's going to be a traffic problem. Well, the factual evidence that they're kids, the size of the road, the number of cars, those are all facts. You can rely on those.
When you say that a proper study is needed for a professional opinion, is it necessary for a printed copy of that study to be turned in as evidence?
If you're going to rely on the printed copy. Any evidence that's being offered, photographs, documents, reports, if you're going to use it, you should have it introduced as an exhibit, and your clerk should probably have one of the little numbered things in Exhibit A and Exhibit B, and it becomes a part of the hearing record. So if anybody has a report and you're going to be relying on that, it needs to be made a part of your official hearing record. So for that reason, if they have a written report, you probably want them to submit it as evidence and leave it with you.
Can you consider a written professional report where the person who authored it is not there, or they have to be there at the hearing to lay the foundation?
Yeah. We're about 4 minutes away from our break. So, the general rule is you want the person offering the testimony to be present, physically present at the hearing. Because one of the things you want to do is, A, if you've got questions, ask them. So that you can, well, wait a minute, did you consider these 3 factors that I don't see in your report anywhere? You want to be able to ask them questions. The other side, the board members. And as a practical matter, most of the cross-examination comes from board members themselves, as you're looking at it and deciding how much weight do you want to accord this report. Is it reliable? Is it accurate? You may well have questions and you want to ask the person who prepared it those questions. So generally you want that person there so you can do that. And part of it is you're weighing their credibility, reliability, and how much you trust the information they are giving. But as a practical matter, they aren't always there, and the strict rules of evidence do not apply, and you can generally accept reports and use them, particularly if it's from a governmental agency. It looks like the FAA has sent you a letter, and it doesn't look like a forged letterhead, it's spelled Department of Transportation correctly. It looks like it's real. You can rely on that even though the district engineer from DOT is not physically present. If you've got a question about such a report, however, it's entirely appropriate to say, I've got some follow-up questions, I'd like to continue the hearing, and you need to bring this person in so we can ask some questions about it. Anything else about hearsay, opinion testimony, the quality of the evidence? But remember, this sort of is concluding part one of our session, but it's also concluding part one of your role in a quasi-judicial matter. Part of your job, your first key job, is finding out what the facts of the case are. And that's what this hearing is all about, the evidence, having the hearing record, and getting that evidence on the record. So, and making sure it's quality evidence, that's reliable, and that you can make a judgment based on that. So, we'll take a 10-minute break. When we come back, we're going to talk about the decision you make based on that evidence. Ready to crank back up? As we're coming back in, let me just ask you in terms of evidence, let me ask you a couple of questions. These were in the handouts on that page one, discussion number one, considering the evidence. Context here is developers asking for a special use permit for an apartment building. And we have various types of evidence. The question is, can you consider this? How much weight can you give to it? Testimony from a neighbor that he'll be able to see the new apartments from his back porch. Can he actually see it? As evidence? No. Yeah, I mean, that's personal observation. I'm here, I'm under oath, I can sit on my back porch and I can see these folks. So as a fact, is it visible from the adjoining property? Yes. Is that going to be relevant to your decision? Probably not, but you can accept that as evidence. How about a letter of support from the minister of the developer's church stating he's an upstanding member of the community and volunteers all the time? No. That's just like the other side of it. You know, somebody shows up and says, hey, wait a minute. I know this guy. I went to high school with him. He was a lying jerk back then. He hadn't changed a lick since then. I can't believe a word. Well, no. How about the petition signed by 25 neighbors opposing the project because it's out of character with the neighborhood? And neighborhood character and harmony is one of your standards. This is a harder one. Somebody comes in and says, I have this petition signed by 25 of our neighbors.
Are they there?
Are they there? I anticipated that question, and each signature has been, they went to a notary, and all the signatures here have been notarized. This is a notarized petition. And a notary means the person whose signature there really signed it. Does that make it any more reliable? No. Does it make them present to ask questions and blah, blah, blah? No. Does their opinion about it actually matter? If you're offering the statement from somebody who's not there to prove a fact that's in the statement, that's hearsay evidence you cannot consider. Should not. You can take it, and my advice to you in that situation is thank you very much, we appreciate it. However, you need to understand we cannot rely on this petition to make any significant finding of fact. But we'll take it and put it in the record, but we really can't use it for much of anything. How about testimony from a neighbor and salon owner about how it's going to injure her property value?
That's significant.
Competing business, maybe. Again, if you're talking about property value, she can offer you facts, but not an opinion. She need to be a qualified expert. How about the letter from the traffic engineer saying why, in her professional opinion, the traffic impacts will be reasonably accommodated by the proposed street improvements? I mean, that's traffic safety, qualified expert. You might have a little bit of a hearsay problem if she's not there to testify about it. All you've got is the letter, so if you have questions about it, why is this turn lane long enough? Is the whatever improvement you made sufficiently adequate? If you've got questions about it, you could ask to have that person come in. But the report itself is generally going to be admissible. How about this on a harder one? I've actually had a boom case like this. The neighbor comes in and says other apartments in town owned by this guy, the maintenance is lacking, they're falling apart, he's building another thing just like this. It's going to be blight in our neighborhood.
Makes no sense.
It makes no sense. And this is a harder case, and I gave you some that are not all clear-cut one way or the other. The case we had from Boone, this is sort of based on, somebody, a particular developer had an apartment rented to students, proposed exactly the same building in a different neighborhood. Same design, same footprint, same owner, same clientele for the apartments. And what the neighbors came in and said, this other project has had 48 complaints to the police in the last 6 months for noise violations. We've had this kind of problems with beer cans in the neighbors' yards, and all the problems for the neighborhood that were generated by that particular development, but all backed up with police reports, photographs, etc. What do you think? I mean, it's a tough one. It's factual evidence. I mean, the person that took the pictures there saying, no, I went over and took the pictures, and this is an accurate depiction of what I saw on the site on a Sunday morning. They had the letter from the chief of police about the police reports and so forth. Those are all facts. And the court said you could take those and rely on them, and there was sufficient similarity. Same developer, same project, same town, same type of neighborhood. It was sufficiently similar that you could consider how much weight you wanted to give it and where you thought that was a reliable indication that the same thing done by the same developer would have the same problem is one of the judgment calls you have to make as a board member. But the evidence you could consider. Just to say that some of these questions get close enough and hard enough that it will keep all of us lawyers gainfully employed for decades to come. All right. Talk about the evidence. We'll slide over and talk some in our next period about making a decision. Start that by noting that the Open Meetings Law and Public Records Law applies to you as a board making decisions. Anytime a majority of the board is gathering to conduct business, you need to have proper notice of your meeting. One part of that is you shouldn't be having informal meetings that are unnoticed or unadvertised. I would avoid the temptation. This comes up more in the context it's not clearly addressed by our statutes, but electronic communication, it would not be good for you to be starting a text message chain with your fellow board members about a forthcoming hearing, even if it's not all at one time, but what do you think about, so, don't. And if you do, a reminder that anything you write down in the conduct of official business is a public record. The fact that it's a text on your personal phone as opposed to a government-issued phone does not mean it's not a public record. If it's a written record made by you in the course of your business, it's a public record. So keep that in mind. Just be careful about your records and so forth.
Can you tweet it?
Tweet it? I would advise all public officials be more careful about your tweets. Your hearing, and I say that without expressing any political judgment. I just hesitate to open my phone these days. Notice of hearing. The statute has a few brief notices about things you have to do about your hearing. Essentially a mail notice to the parties, the applicant, the immediate neighbors, post a notice of the hearing that you're going to have on the site so that people are aware of it. Well, unlike a legislative notice, there's no statutory requirement for a newspaper published notice. So an evidentiary hearing, since if a legislative hearing, the purpose of the hearing is to gather public opinion. An evidentiary hearing, the purpose is to gather facts about a specific case. So the statute doesn't require broad public notice in the context of a newspaper ad to let the whole public know, but more focused advertisement to those who are immediately affected by that decision, the applicant, the property owner, adjacent property owner, hence the posted and mail notice, not the published notice requirement. But if your ordinance says something more, you got to comply with whatever's in your ordinance. So if your ordinance says do a published notice in the newspaper, you got to do it. If it says mail it to everybody within 500 feet of the site, you got to do that. Whatever your ordinance says in addition to, as long as it is more than, not less than, the state requirement. There's no statute on the order of the hearing. I encourage you, how many of you have rules of procedure for your board? It's a good idea to have those and follow them, not required. But having a standard order of procedure, opening, explanation of the case, the applicant, the staff, the neighbors, an order you follow on that and follow it consistently is a good idea. But there's no mandate in the statute other than collect the evidence, deliberate, and make your decision. All of your deliberation has to be an open session. There was a time, I'm old enough when I first started, and my predecessor, I've been at the school right now 30 years, my predecessor had been there 40 years before I got there. And he was telling me when all this first started, a board of adjustment would typically in North Carolina hear the case and then adjourn to the jury room to deliberate and come back and announce their decision. And that it was a great shock to them in the 1970s when they had to start doing their deliberation in public and talk about, well, wait a minute, we've got to talk about weighing this evidence in public? That's going to inhibit our free discussion. Well, that's the law. You've got to do it that way. It's been that way for 40 years now. Your discussion needs to be about on the standards, how this does or doesn't meet the standard, and it needs to be based on the evidence in the record. One of the things you have to be careful about, some local governments will set up their meeting in two distinct phases. They will gather evidence, and then somebody will make a motion to close the hearing and move to deliberation, and then they'll start deliberating and then vote on the case. You can do that, but you've got to be careful. If you close the hearing, the collection of evidence, then you can't take any more evidence. So you close the hearing, some of the people leave, you're deliberating, and you have a question. You would like some clarification. You want to talk about a potential condition and see if the applicant is okay with that condition. To see if the neighbors feel like that condition will meet their concerns. And there's some facts about that you're getting. If you can't gather any more facts once you close the hearing, unless you re-advertise the hearing. So my suggestion to you is don't close the hearing until you vote. You leave the hearing open in case a question arises and you want to ask a follow-up question or get some more information. Now, discussing it amongst yourself is not getting additional information, and asking a clarifying question isn't always getting new evidence. We have a case where the board heard the case, it was late at night, closed the hearing, everybody went home. They came back the next month to deliberate what they had heard the previous month, and they had a question or two they wanted to ask the applicant. Well, we're thinking about this condition, and is this acceptable to you? And the court said it was okay to ask a question as long as you weren't gathering any new evidence. If you're gathering new evidence, no. Simply asking a question, discussing it amongst yourself is okay. But I'd be very, very careful about that. The other side of that equation, again, not to pick on Boone, Boone had a particularly contentious case. Some of these cases have a life of their own, and they just go on seemingly for decades. They had a case where somebody was trying to build a medical, I think it was an office building. I think a medical office building adjacent to a residential neighborhood. Neighbors strongly opposed. The people with the office building had deep enough pockets that they were persistent. And this case, individual case went up to the Court of Appeals, I think 3 different times over the course of 5 or 6 years. But one time, it went to the courts, all the way to the Court of Appeals, and they said there wasn't enough evidence to make the proper decision. And they remanded, or there weren't sufficient finding of facts. There was a lot of evidence, but your finding of facts weren't clear. The evidence was somewhat contradictory. So the court remanded to the board to enter new findings of fact. Not to gather any more evidence, but to make new findings of fact based on the prior hearing. And a bunch of the neighbors were there. And this was a special use permit decision made by the town council, not by the board of directors. Town councils, I dearly love elected officials. I commend all of you who suffer the slings and arrows of standing for election and serving your communities in a thankless task. But it's difficult for elected officials in a legislative body to make quasi-judicial decisions because it's inherently different from the responsiveness and constituent care and the talking to your constituents and finding a solution that benefits all. That's not what you're doing in a quasi-judicial context. And it's sort of out of nature for an elected official to say, I can set aside my normal legislative role and act in a quasi-judicial capacity. And the Boone case was a good example. They went back to the town council, and there were 8 or 10 neighbors who were there to watch them make their new findings of fact, and they all wanted to speak. And the mayor said, well, since you're all here, 3 minutes apiece, we'll let you have your say before we move on. No. The court said, wait a minute, that's taking new evidence. And you can't take any new evidence. The only purpose of this remand was to make your findings, deliberate those as you saw fit, but you can't take any new evidence after the hearing is over. And simply allowing these people to express their opinions once again as to why this project shouldn't be allowed in their neighborhood is taking new evidence. Go back a 3rd time and do it one more time. So be careful about that. We've talked about burden. Burden is on the applicant to show you they meet the standards. But once they do, once they make that basic case, present you the evidence they meet the standards, it's all over. You have to give them their approval unless the opponents can present evidence to you, sufficient evidence to show that they don't meet the standard. And if there's conflicting evidence, your job is to decide which one is right. So if the applicant presents their case and there's no evidence on the other side, it's easy. Your job is done, you issue the permit. But that burden shifts, once that evidence is there, the burden shifts to the opponents. So you say, okay, have the opponents, and it's not a reasonable doubt standard. We never have the sort of criminal beyond any reasonable doubt. It's a preponderance of the evidence. Is there substantial evidence? 5149, do we believe these are the facts versus those are the facts? So it's whichever side you think has presented sufficient substantial evidence to convince a reasonable person that their version of the facts is correct. Everybody good at that? One of the things to be very careful about, if there is a dispute about that, and I don't want to get overly legalistic, but do not just check off, here are our 4 standards. Is this compatible with the surrounding neighborhood? Yes. Is it a significant adverse impact on property? No. Those are not your findings. The terminology gets very confusing. Those are the conclusions you are making as to the application of the standards. I had a case from Asheville. I've got a local case. Shoney's of Inca. Is Shoney's of Inca still in existence? I doubt it. There aren't many Shoney's left. This is probably a 30 or 40-year-old case. They applied for a permit, did their hearing, a special use permit, could have been a variance, one or the other. Quasi-judicial. And the board went down the checklist. You know, the 4 standards were there, yes or no. Did they meet the standards? Yes, 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 yes. Grant the permit. The court said, oh, no. And the board said, well, we made our findings. The 4 findings we had to make. We checked off on all 4. We're good. And the court said, no, no, no. Those are your conclusions. How did you get to those? What findings did you make on the facts? And in that case, there were some disputed facts as to whether or not they met the standards or not. And a checklist in that context is inadequate. Those are your conclusions. You need, where there are contested facts, to say, we believe the facts of the case are 1, 2, 3, 4, A, B, C, D. A paragraph or so as to what a majority of your board thinks the facts of the case are. And those facts need to be, in turn, supported by substantial evidence in the record. And then once you've determined the facts, you apply those facts to the standards at hand. It's a little confusing, but be careful to clearly explain in your decision document, if there are contested facts, which ones you thought were correct. You don't have to elaborate a lot on the whys, but you have to explain what you thought the facts of the case are. We found they turned in an application. They could not build without expenditure of $3 million to build a bridge to the site or whatnot. You need to lay out those facts.
When you refer to a majority of the board, are you suggesting that when we talk about contested facts, we actually take a vote as to which facts we believe to be true?
Some boards do vote on the facts for each finding. Voting is done in a lot of different ways, and you have some flexibility. It needs to be clear if there are contested facts. And again, a lot of times you get a non-controversial case, the facts are stipulated pretty much. There's no disagreement about what the facts are, and that's fine. You don't have to worry about producing some elaborate document findings where you've got a non-controversial, clear case and no disagreement about the facts. You may disagree about the application of the standards of those facts, but no factual disagreement. But if there is disagreement, you need to figure a way that you get a majority of the board to know what the board itself concluded the facts are, and the board acts by majority vote. The easiest way is to have a draft set of written findings of fact. Somebody makes a motion to approve those findings of fact, and the whole board votes on it. But that may be more, that's not necessary to do it that way. That's sort of a clean, clear way of doing it, but it can be a little time consuming. So sometimes you can just sort of, everybody agree with this, and there's a nodding of heads, and you move on. But somehow the record and the minutes need to reflect that puts a little burden on the clerk to make sure that somebody stated, we think these are the facts, there was acquiescence among the board or something to reflect that.
In Asheville, for the HRC, Historic Resources Commission, there are sort of basic findings of fact, how it meets the guidelines that are written or read actually at the hearing by the HRC. But we still follow up with the attorneys writing findings of fact and conclusions of law that are adopted at the next meeting,
Yep.
and that's what we do with the Board of Adjustment too. So the Board of Adjustment will say yes or vote yes or no, but it's followed up with a written findings of fact that are taken from the meeting minutes.
All right, we'll talk in a second. There's your decision and there's your decision document, and those are two different things. But that's sort of the gold standard, is to have a written document prepared that's actually adopted and approved by the board. One of the things that was by far the most common practice in the past, that I think is gradually going away, and as a lawyer, I would advise you to hasten the day when it completely goes away, is to not have a separate decision document, but to rely on your minutes to reflect that discussion and the findings. And that's what everybody used to do. And I think that's puts you on a considerable disadvantage, and I would encourage you to have an actual decision document for each case that is clearly approved by the board. It gives you a discrete, this is what we thought the facts were, here's our decision. And later, I'll point out, this is critically important because that's the decision document that starts the clock for appeals and everything else. So you really need to have that. It's not technically required by statute, yet strongly implies that you should have. As we mentioned earlier, you apply those, given these facts, we conclude it does, if you're, for example, saying it is an unnecessary hardship, it would be useful to say why it's an unnecessary hardship. And the reason I think you really need a separate decision document, probably prepared after the fact. Some jurisdictions, mainly larger cities over 100,000 or so, will have a draft decision document at the hearing. So somebody can say, I move to approve the proposed findings of fact and conclusions of law as outlined, as handed out to staff as agenda item 14C with the following 3 amendments. But most, unless you're a really big jurisdiction, most folks don't go to that time and trouble. If somebody writes it up after the fact, it's voted on and approved. But on behalf of the staff that are writing it up, you need to be pretty clear in your motion, because your order, the decision has to say why you concluded the standard was or was not met. And you don't want the staff to have to be speculating as to why the board thought that was the case. I have friends who work in private law practice who contend that, wait a minute, I saw this order drafted by the attorney and adopted by the board, and it has a whole lot of stuff in it that I don't remember being discussed or even the hearing at all. And the attorney really shouldn't be. Can't create things that you as a board didn't do. So they can reduce that to writing, And they can clean it up a little bit and clarify it and make sure it accurately reflects what you, but it has to reflect what you as a board did. So your responsibility is, and you can't draft that on the fly. You can't sit there in a meeting and say, well, and just, I move, we find there's an undue hardship because, and out comes a carefully crafted paragraph that you're composing on the fly. I've tried to do that myself as a staff member who's worked in this field a long time, and it's hard, and usually not very successful. So a lot of times you are doing that after the fact. But what you're doing after the fact is reducing to writing what you actually did. So you have to give your staff enough information that they can put that stuff together. Everybody good with that? Conditions, yeah.
I don't mean to take up much of your time with this question, but could you give one or two what you would consider classic examples of an unnecessary hardship?
It's hard. I can tell you the variance standards in the statute, it's essentially the same standards been in the statute for cities since 1923. It was originally written into the Standard State Zoning Enabling Act, promulgated by the Department of Commerce when Herbert Hoover was Secretary of Commerce. Had essentially this same proposition, and the idea was you're writing a regulation that's applying to all land uses in the city, and we can't anticipate how this ordinance is going to apply to all the individual lots and situations that might arise in the future. And we need some tool that gives us some flexibility to tailor the terms of the regulation to these individual circumstances. But we don't want to write that ability to provide that flexibility so broadly that an unelected board of adjustment is going to amend the ordinance and dispense seat of the pants of justice as they see it. We want them operating within the fairly narrow constraints of furthering the intent and purpose of our regulation, but allowing tweaks as necessary to deal with these unanticipated, unusual, fact-specific situations that are inevitably going to arise. So that's the context that that original provision was written, actually it was written in the New York City's 1916 zoning ordinance, incorporated in the model code and into the North Carolina statutes in 1923. And we're still living with it today. But it was that dual purpose of allowing a little bit of flexibility, but within the constraints of the ordinance for these unanticipated, unusual, applying the ordinance to the facts on the ground. It was intentionally written to be very difficult to get a variance. That it's only designed to deal with these sort of quirky situations where if we applied the law literally, it would be a real burden, and that burden would serve no public purpose, and the intent and purpose of what we're trying to accomplish could be met with a little bit of flexibility. That's the legal context you're working in. You want to guess statewide about what the average is for number of variance applications that are approved? That meets this very demanding, extremely difficult standard?
95%.
Statewide, and it's funny, this is true, we've done some empirical work here in North Carolina, but it's also consistently true across the country. It's almost the same. Now there is, I should say, there is a lot of variation. I've dealt with communities that have never granted a variance. I've dealt with others that if you paid your $20 and found the meeting room, you were walking out with a variance. There's some on either extreme of this. The statewide average is about 80%. How many of those meet the demanding legal standard? I suspect it's something less than 80%. And there is some notion of, we're going to give folks a little bit of flexibility, a little bit of, look, a classic example would be somebody's got a steep slope, you've got on one side of the lot, you've got 15-foot side yard setbacks on each side. They're going up a hill, you've got a little flat side, they're building on a plateau. They need to move over 3 feet, because they go this way, they're going to be falling off the side. But if they go that way, there's no worry of harming the neighbor, because they're up the hill another 50 feet in elevation, and sliding the house over 2 feet isn't going to hurt the neighbor on the upside. It's going to protect things on the downside. So a little bit of tweak because of that topography of the lot and the side yard setbacks is reasonable, and trying to go to the expense of stabilizing the slope or that stuff is just cost prohibitive, and it would make sense to let them slip it over a little bit. That would be an example. You cannot do a use variance. You cannot allow a change in use by variance, flatly illegal. It's been illegal by case law since 1950, prohibited by the statute since 2005. So if somebody says, I would like to operate an auto repair shop in the backyard. And yeah, the ordinance, the home occupation list does not include auto repair. But I want one anyway because I'm a good mechanic, I'm getting old, I'm retiring, I'd like to do some part-time out back. In my garage, I got space. What's it going to hurt? I'll promise to do it all indoors, only between 10 a.m. I don't get up very early. Knock off early, I'll do it between 10 and 3 indoors. What's it going to hurt? All my neighbors are here to say, Dave's a nice guy. He'll fix my car cheaper than those crooks at the dealership. Let him do it. Give me a variance. No. You can't allow me to do a use that's not allowed by the ordinance. Because it's simply, there's no way that can be consistent with the intent and purpose of the ordinance. The ordinance says, don't have an auto repair shop in a residential neighborhood. If I want to do that, I need to not ask for a variance. I need to go to the town council and say, you need to amend your ordinance to allow auto repair shops in residential neighborhoods under the following 8 conditions, and make it, amend the ordinance, not do it via variance. You can always impose a condition on your approvals of a quasi-judicial decision. But 2 things you need to be careful about. 1, relate that condition to the standards for approval. The standards say harmony, and we need these 3 things to make it more harmonious or to prevent adverse impacts to neighboring property values or whatever the standard is. Relate the condition to the standard. And have some evidence in the record to support the need for that condition. What you need to avoid is the temptation of, well, we got the applicant over here who wants this, we got the neighbors who are opposed, let's see if we can find something in the middle to craft a solution that everybody will go out of here somewhat happy. You really don't have much of that opportunity in quasi-judicial. That's sort of the nature of conditional zoning. You get into legislative conditional zoning, one of the reasons local governments increasingly in North Carolina are adopting it. Some of our larger cities are doing 80 to 90% of all their rezoning as conditional rezoning. Because it does allow you to have that kind of balancing the interest of what the applicant wants, the neighborhood concerns, crafting a compromise and putting something together in a legislative context, perfectly legit. Our courts and legislature have opened the door to doing as much of that as you deem feasible and appropriate in your jurisdiction. Very few limits, but not a lot. In the quasi-judicial context, that's rarely the situation. If you're imposing a condition, you need some evidence to support the need for that condition. We need this because otherwise it would be a traffic problem, or it would be inharmonious, or it wouldn't meet our guidelines. and there's evidence to support that. You want to be careful about doing that. Making your decision a motion. We talked about findings, but just be clear in making your motions what you're doing, because a rationale for why you're doing it, what findings you're making, what standards are met or not met, why they aren't met. You can't just get tired at the end of a 3-hour hearing and say, I've heard enough. Go away. You're denied. One of the rights you have is to know the rationale for the decision. The written findings of fact and conclusions of the law dates back to the 1970s. The seminal case of Chapel Hill Town Council denied a permit for a gas station downtown, a special use permit, in the early 70s. And they had a hearing. You had Humboldt Oil and Refining Company presenting their case as to why they met all the conditions for a special use permit. You had a room full of neighbors saying this is awful, this is terrible, it will be the end of the village character as we know it in scenic Chapel Hill. The last thing we need is another gas station downtown and we cut down a nice old shade tree. The minister from the church across the street, the pillar of the community, said, this is awful, we don't need no stinking gas station across the street. And at some point in the evening, the town council said, we've heard enough. And we'll all go away and darken our door no more. We're out of here. That case eventually wound its way to the state Supreme Court. And they said, one of the rights the applicant has is to a written decision that explains the facts and the rationale for the decision. A simple conclusion, no, is inadequate and violates their due process rights to a fair hearing. And we are still applying that rule 50 years later now. Very importantly, your vote on the decision is not your decision document. We'll come back to that after we deal with voting. Everything you do is you vote with a simple majority vote, except a variance, which requires a 4/5 vote of the board. Everything else is a simple majority of the entire board. Now remember, we're talking about not a majority of those present and voting. You take the size of your board, all of your members, including anybody who's not there, you subtract from that any seat that's vacant, if there's not a person in the seat, or if the person in that seat has a conflict of interest and is prohibited from voting. You don't count that seat in computing your majority, because if it's vacant, you can't get a vote out of that seat one way or the other. And if they have a conflict of interest, they can't vote one way or the other. So those are not considered members of the board for the purpose of that particular vote. But then you need a majority of all of the seats that are eligible to vote. So you do count the seat of somebody who is simply homesick, on vacation. That seat counts in your calculation. But somebody who has a conflict of interest abstaining, you don't count that seat.
So if you've got two matters and there's a conflict for one, do you ask, is the board member that has got a conflict to just not sit for either one of them, or how do you handle that?
If you've got a conflict on one case, but you've got two cases on the agenda, you only have to sit out in case you've got a conflict on. You're not excused from the whole meeting, just that individual case. It's a very good idea to have alternates, and the purpose of having alternates is, people are going to be sick, they're going to be on vacation, but occasionally they're going to have a conflict, and the alternate can step in and participate in that particular case. If somebody's absent, they can participate in all the cases. But it may be that you've got 5 cases, you've just got a conflict on one, the alternate can sit in on that one case, and then the regular member resumes their spot on the board for everything else.
So if you've got a situation where you have 11 members, 6 are present. Vote is 5 to 1, you have to count the other 5 members as
Yeah, 11-member board, 6 people present, 5 to 1. That's including a majority of 6, but you gotta have a majority of 11. But 5 is not a majority of 11, you gotta have 6. Now, if some of the people who are absent, your 5 people who are absent, if the seat's vacant, you don't count that seat. If they have a conflict of interest, you don't count that seat. But if they're simply not present, now this is true, as a historic commission, I have to tell you, I'm not sure this is true for a historic commission. It is true for a board of adjustment. It is true for the council. And it is true in any zoning issue. The historic district standard is maybe different. I think this rule is going to apply to the historic commission. But I would have to look at that specific statute before I gave you a official, informal opinion.
The PC concept may solve that question.
Right. Yeah, if the seat's empty, like if you had a board of adjustment with 5 members and the vote to, say you have a variance request, you've got a 5-member board and 1 member is in Florida visiting relatives, and the vote to grant the variance is 3 to 1 in favor. You have a variance? No, because you got to have 4/5 of 5. You've got 3 votes, that's only 3/5 of 5, not good enough. Suppose that member's not in Florida, they have moved away, vacated their seat, and hasn't been filled yet. So you only got 4 active members of the board, 1 vacant seat. The vote's 2 to 1 for a variance. Do you have a variance?
Yes.
No. Trick question. Your board is only a 4-member board because you've got a vacant seat, but you still got to have a 4/5 vote. 4/5 is 80%. 3/4 is not 80%. 3/4 is only 75%. No. That's when you need to have an alternate or a new appointment made.
You're not counting the alternates that may be able to consider?
If you have an alternate present, the alternate takes the place and you never get to this calculation. You count the alternate as
a member at that point.
once the alternate is seated, they have all the rights and responsibilities of a regular member for that case. So they hear the case, they vote, and you don't have to worry about reducing the size of the board, which is always a good reason to have alternates if you can.
What is the basis of that statute?
What is the basis of the statute?
Where does it come from?
Where does it come from? Which one? The 4/5 rule or the how you compute the majority?
How do you compute the majority?
The statute used not to say, it just said, the statute used to say, prior to 2005, the statute just said you had to have 4/5 of the board. And it was unclear what the board was. But you're talking about the language in the statute says you must have 4/5 of the board. And so, well, what does the board mean? Does the board mean those present and voting? And we didn't have the statute wasn't clear, the case law wasn't clear. I had the unfortunate circumstance of getting deposed once. The subject of a deposition is painful. I wouldn't wish it on it. I'd rather go get a root canal than be a witness in a deposition. But a colleague and I at the School of Government, a lawyer, had called us and asked for our opinion on how to interpret that statute. And I gave them my opinion, and I looked at other case law in other states and what I thought the interpretation ought to be. I had a colleague who came to the opposite conclusion. I have to say he hadn't looked at as much statutory stuff in other states as I had, but it was a good opinion. And this is a case that went on for years. It got somewhat visibility. And somebody said, you know, we need a legislative solution to this. We just decide one way or the other what it is. This is a long way of telling you that actually after several disputes like that, of somewhat legitimate answers on both sides, the courts finally said, in a case from North Topsail Beach that you don't count vacant seats and seats where there's a conflict, and the legislature fairly quickly wrote that into the statute to codify that. So the answer is we had a court case, and it was undecided, nobody knew. We had a court case that sort of said that, and the legislature said, let's just have a clear rule one way or the other, and that's the rule they chose. I think it's the right rule. Since the legislature and the court eventually agreed with what I thought the law was. It was obviously right. I mean, there's a completely legitimate argument on the other side of that as well. Well, we just need to have a clear rule one way or the other. The last point about this, and we'll take a break in just a second. Your written decision. When you vote on the case, you made your decision. But your decision is not effective until it is reduced to writing, signed by the chair of the board, and filed with the clerk to the board and mailed to the parties to the decision. So you need a written, the case law, this goes back to that Chappell case from the early 1970s, so you had to have written findings of fact including the laws. Now you could do that in your minutes. You say the minutes reflect the discussion of the board and their findings and their decision, and it's written when it's in the minutes, but it's not effective until the board approves the minutes, and it's one of a bunch of things, and it's difficult to lay out all these facts in your minutes. So when our statute was modified in 2013, it did not specifically include a separate written decision document, but the whole statute is predicated on the assumption that there will be such a thing. Because the statute now says the decision is not effective, which means the clock for appeal to court, which is a fairly short clock. You've only got basically 30 days to go to court to appeal a quasi-judicial decision. And that clock, though, doesn't start running until you have the effective date of the decision, and the decision is not effective until a written copy of the decision is mailed to the applicant and filed with the clerk of the board that made the decision.
What date do you use?
You use the date, the last of those two dates. Which date did it get filed with the clerk to the board, and which date did it get mailed to the applicant and anybody else who requested a written copy of the decision at the hearing.
So if the applicant says they didn't receive it, that doesn't matter.
Doesn't matter if you've got that's why I think a separate written document that you can date, have the chair sign it, and you hand it to the clerk to the board. It doesn't have to be the city clerk or county clerk. It's the clerk to the board that made the decision. That clerk should have a date stamp and say, boom, I stamped it. The person that drops it in the mail should attach a little certification to it that says, I mailed the attached decision document to the listed addressee on 31st of January 2019, and then you've got a clear date, 30-day clock starting to run, and you know exactly what the decision is, what is in it, what's not in it, and it's clean, clear, straightforward. Now, if you never file a written copy with the clerk, that clock's not running. A tidbit for the lawyers in the group. If you've got a case you thought was long ago dead and gone, you might want to check and see if a copy of that was filed with the clerk to the board. Otherwise, there may be some life in this old case after all. You can mail my checks too.
I'm still having a little trouble with the may prepare the draft decision prior to the hearing.
Right.
And like, how can I draft a decision if I haven't heard the evidence yet?
Sure. Good question. How can you draft how can you do a draft decision if you haven't heard all the evidence? That would be a challenge for the board member, perhaps. Typically, a draft decision is going to be written by the staff or the parties, and they will say, this is a proposed decision. Then you have to be careful if you've got the findings of fact that the evidence that's submitted really supports the facts that you've got. But you can do a forecast in more contentious cases where you've got 8 lawyers involved in a 3-day hearing. Somebody's going to be, you might have 3 different draft decisions. And each side is presenting their own proposed decision for you to approve. What the board has to decide, even if it's a draft prepared by your own staff, much less by the applicant or the attorney for the neighbors, you would only approve it if you agree that the evidence you've got supports those findings and you agree with the conclusions they are proposing. 3 minutes away from a break. One of the things I did not mention in the slides, how many of you send a quasi-judicial decision to an advisory board for review and comment before going to the decision-making board? Anybody do that? Like a special use permit would go to the planning board first and then to the city council for a decision?
Conditional use permit.
Conditional use permit?
We hardly do any, but that would go to planning and zoning, but it's not quasi-judicial. Oh, wait. We haven't. Guess I'm.
I mention this because in some parts of the state, that is a very common practice. I was shocked when we did some of our survey stuff. As a lawyer, when somebody first told me that, I said, wait a minute, somebody's got legislative decisions where you have to have a mandatory referral to an advisory board and quasi-judicial decisions mixed up. It's nuts. Why would you send a conditional use permit to the planning board for review and comment when the other board's got to hold an evidentiary hearing, witnesses under oath, cross-examination, and everything they did at the planning board, hearsay, inadmissible, rah, 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 all sorts of legal problems. Why would anybody do this? In North Carolina, over half of all the jurisdictions in the state send special use permits to an advisory board for review and comment before going to the decision-making board. It gives me, I think, a great idea as a planner, great idea, citizen engagement, full deliberation, rah, rah, rah. As a lawyer, it gives me heart failure. One of the jobs of your city and county attorneys is to guide you across the proverbial cow path without stepping in anything untoward. For those of you who have a rural background, somebody who used to play in cow pastures occasionally in my bare feet, I can tell you, you need that guidance from time to time. That's just one more cow patty you can step in. I advise you not to do it. But it's legally permissible. The new statute we're going to talk about a little bit after the break, there was some debate about simply prohibiting that, as most of you do. But the legislature decided not to prohibit it. So you can send a quasi-judicial matter to an advisory board for review and comment. But the new legislation says you cannot rely on anything they tell you in making a decision. Which I think is the right answer. One might question, well, the desirability of sending something going through the time and trouble for the applicant, the neighbors, the board, if the decision-making board can't use what they're getting from it to make a decision. But some folks are going to still do it because it is sort of a dress rehearsal. It's a chance to identify issues, to allow the applicant and neighbors to maybe talk about some issues of concern and work it out, amend the application. So, I mean, I don't want to discount that it has zero value, but you got to be careful if you're doing advisory review.
So, sort of curious, speaking of cow patties, when you're forecasting 3 different potential outcomes in a contentious matter, would it make more sense, much like we're familiar with adopting minutes 30 days after a decision, or a court will draft an order that reflects its decision, to make that decision document be presented at the next hearing?
Yes, and some jurisdictions do that. The statute allows, the problem with that is you don't get, that adds another 30 days to the decision. So the statute allows you to reduce that to writing, and as long as the board chair signs it, and sends it out. You can go ahead and do that prior to the minutes. But my experience is that if it's a big contentious case and you want the whole board to look carefully at that decision document, that it's often prudent to hold that over and present it to the full board and let them look at it and vote to approve that decision document. So you get, yes, this does accurately reflect what we talked about in the decision and the conditions, and do that at your next meeting. But it does add an element of time. And statewide, the average for a special use permit is around 70 to 80 days. 60 to 90 in that range is the typical, but it varies a lot. In my hometown of Chapel Hill, the average for a special use permit is 18 months. And most of them take more like double that. If you get out with a special use permit in under 2 years, you have got an easy, non-controversial project. Chapel Hill is a bit atypical. If we were a bunch of Duke fans, you'd be saying that you're absolutely right about that. But anything else on that before we take on your decision document and making your decision? Motions, anything, voting? All right, if you've got last things about anything quasi-judicial, we'll take them up in the Q&A, but when we come back, we'll talk about our new legislation and a little bit about affordable housing. We'll be out here about 4:30.
You know, the way made some mistakes.
Okay, everybody, come back to us, please. We need to make an announcement, too. If there's anyone parked in this lot back here, please move your car, take it to the garage. TD Bank is going to start towing. So we don't want anybody towed. I went over and spoke to the bank manager. He's graciously given us a few minutes.
Even if it's in the handicap zone?
How many would be in that category? Okay, Dot, if you're in an ADA spot, let me go talk to the bank manager for you, Dot. But for anybody else, please move your car to the garage, and I'm going to go tell the bank manager we need to sign up. Okay, thank you.
All right, parking. Always a problem. Where you go? All right, our last. I'll just conclude what the thing on the appeals is 30 days, just a reminder. That 30 days runs from the effective date. We talked about that. Be sure you know what that is and everybody else knows what it is. And the last point on that slide is just a reminder. If one of your special use permit cases, a variance, goes to the U.S. Supreme Court, there is never another hearing on this matter. So one of the reasons you need to do your evidentiary hearings carefully and correctly is that is the only evidentiary record there ever is. Everything else, from the Superior Court, the Court of Appeal, to the Supreme Court, is a review of what you have done and the record you have established. So one of the reasons for being careful and getting the evidence right and the like is this is the only shot at it for you, for the applicant, for the courts. So try to get it right. All right. I'm going to zip through this fairly quickly. I will pause where you want to pause. We'll do this first. We'll do a little bit on affordable housing. And I can assure you, I can exhaust my knowledge on affordable housing technicalities fairly quickly. So that will be, we'll cover that. There's some important issues there. And then anything else you want to talk about. But we will finish, we finish before 4:30, we're done. But we won't run beyond that. All right? This new law, we've got a bunch of resources coming. There's that little website with the thing, we being the School of Government. Primarily my colleague Adam Lovelady and myself are putting together a fair amount of background materials. We've got the book, we've got the cover, we don't have the book. The book is in editing. It should be out by the end of the year once the editing, proofing, and layout is all finished. There's an annotated bill that we're putting up on the website that shows how the new law relates to the existing law in terms of using strike through for the things that are deleted, underlining for the new language, footnotes on all the changes as to why they are there. It's long, it's a couple hundred pages, like 600 or 700 footnotes. Those of you who want to know the nitty-gritty details, it's all there. I encourage you to look at it. We're doing a checklist for local governments. Everybody's ordinance is going to need to be updated. All 500 zoning ordinances, you're going to need to at least tweak your ordinance to bring it into compliance with the new statute. And we'll have a checklist of things you need to look at and do. And we're doing a series of regional workshops that will be 3 hours or so on the new ones. We'll do one here in Asheville, Charlotte, Triangle, Coast, and so forth in January. Those are all coming in January. And as soon as we lock down the dates, we'll send that around to anybody who needs to follow up on all this. So what is it? It's basically a policy-neutral, good government cleanup of these statutes. These statutes were first adopted, the first piece of these were adopted in 1905. They've been new pieces added almost with regularity. The zoning statute, the subdivision statute, the housing code, the building provisions, historic districts, and so forth. It has become a relatively unwieldy and somewhat disorganized set of laws. I deal with this stuff every day and have been for decades. And somebody will call me and say, well, where's the statute that says X? And I will say, well, I know it's there in the statute somewhere. I may have even helped draft it, but give me a minute. It's going to take a while to find it. At least I think it's there. I'm getting old enough now that I remember we talked about amending that statute. Whether it actually got amended or not, let me look. But it was just hard to find as part of that. And plus a lot of it just had old language that was antiquated. It needed cleaning up. So the whole notion was, let's just a sort of the good government approach without changing the balance of power between the development community and local governments. Let's just pull this, stop a minute, take this thing apart and consolidate the city and county statutes, reorganize this in a way that people can find it, and clean it up as we go, so that if there are some consensus modernizations we can do, let's incorporate those while we have the opportunity to do that. The first draft of this was done in 2014. The House passed it in 2015. The Senate passed it in 2017. And finally, both houses passed it in 2019. It went through 40 or so different drafts. It was a long effort to get it done, but it is finally done. The three main things it does: it consolidates the city and county statutes. We used to have a parallel set that were almost the same for cities and counties, but over the years, differences creep in. The city statute gets amended, but the parallel, that's my sound. Can you hear okay anyway? Yeah. I'll speak up. But over time, there'd be a slight wording difference between the city statute and the county statute. That was kind of confusing to folks. There'd be slightly different procedures for one than the other. Or a city would have an authority and the county wouldn't. And the question would be, was that intentional? Did the legislature mean to do that? Or was this just an inadvertent change? So part of the idea is, rather than having a parallel set, is to have one set of statutes that apply to both cities and counties. but retain any intentional difference. So that was part of it. And so parts of Chapter 153A for counties, 160A for cities will merge into one section in the new 160D. So it's a new chapter in the general statute. That's why it's called the 160D project, because it creates a new chapter in the general statute, 160D, that only relates to planning and development regulations. So all the planning and development regulations are consolidated, put into that one new chapter. Then reorganizes it into a more coherent framework and adds these sort of consensus cleanup. It's not effective until January 1st, 2021. The main reason for that is to say, look, it's going to take us some time. We don't want to put a burden on folks. Let's give folks 14, 16 months, 18 months it turned out to be, to think about this, clean up the ordinance, not be overly burdensome. Plus, a lot of changes were being made to the statute in 2019. And anything that was being done in this past legislative session, the idea is that should be incorporated into the bill. So if you reform the farm bill and you change the statutes on agricultural and zoning in the farm bill, you don't want to repeal all of those inadvertently and start over again next time. So you want some time to incorporate what was done in 2019 into the statute before it's effective. Because it repeals all the old stuff and starts over with a clean slate as it was. So we've got until 2021. So the highlights of some of the changes. Boards, all the boards, planning board, board adjustment, housing appeal board, historic preservation, the whole, put into one article and with a common organizational framework for each board, creation of the board, its membership and its duties. So we have sort of a consistent framework. It's all there in one article, and there's not a board hidden away that nobody ever heard of somewhere else. But it doesn't really change your duties or makeup of the boards. It just sort of consolidates it into one spot. It does get a few things that are new. It explicitly allows each board to have rules of procedure. The governing board, your city council, county commission can adopt that for your board, and if they don't, each individual board can adopt it on its own. So the first chance is the governing board can adopt rules of procedure for your board. If they don't, you can adopt your own. You don't have to, but you're allowed to. Once you adopt rules of procedure, you've got to follow the rules you've got. Secondly, all board members need to take an oath of office. Many boards already do this. It's a good idea, but it's not mandatory. It will be mandatory as of 2021. So you take, when you get appointed, you assume office, you swear to faithfully execute the duties of your office, to obey the Constitution, and so forth. So it's an oath of office that you take as a board member. That's good because that helps establish you as an officer and helps with liability issues and so forth going forward. Clarifies the appointment process. All appointments to boards are to be made by the governing board. They can delegate some of that to the manager or somebody else, but absent an explicit delegation, the appointments are to be made by your elected officials, and they can have a process to solicit applications for board membership and the appointment process or not, but it's up to them. So that's pretty straightforward. A planning requirement. You need to have a comprehensive plan or a land use plan. That is entirely optional. It is not a mandate to have a plan. But if you don't have a plan, you can't have zoning. All right. So, this has always been the assumption when the Zoning Enabling Act was adopted in 1923 that I mentioned earlier, it said all zoning shall be in accordance with a comprehensive plan. What the courts interpreted that in accordance with the comprehensive plan say, that means you do a comprehensive zoning ordinance for your entire jurisdiction and you're good. You don't have to have a separate plan. The statute now says you don't have to have a plan, but you got to have it in order to do zoning. And if you don't have it by July 1st of 2022, you don't have the authority to do zoning. You want to guess where the suggestion for adding this to the statutes came from? You're asking where did this arise? As somebody who I was engaged in drafting of this over the last 5 years, so I pretty much know where all these bodies are buried, where they came from, for this particular bill. As the sort of secretary to the group writing all these down. Anybody? Planners? City attorneys? It was the development community, the home builders were the first ones to ask us. They said, wait a minute, if you're going to tell us what we can and can't do with our property and how we do it, there ought to be some planning behind all of this. We don't want you just willy-nilly adopting these zoning regulations without some thought, some analysis, and some planning underpinning it. And we would like to suggest that a plan be required. So as of 2022, you need a plan. Now, the statute gives you a great deal of latitude as to what that plan is, how elaborate it is, and the notion is, and Montreat's different from Asheville. And Asheville's different from Charlotte, and that's different from Clayton County. We have a huge 650 jurisdictions in this state. There are very different levels of development. Did you know, as an aside, this will help you in cocktail party conversations. Over half of all the population growth in North Carolina in the last 2 years is in 2 counties. We have 100 counties. Some of our counties are growing very rapidly and have needs for a lot of this time. Over half of our counties are losing population. And a lot of our population growth is, of course, concentrated in the Charlotte metro area, the Triangle, and then to a lesser extent, the Triad, Asheville, Wilmington, and some of our other larger municipalities. Our rural areas in the state are losing population. A little bit, not a lot, but actually, anyway, the notion there is that they're very different. If you're in a small rural county that's losing population, you have a very different situation than if you're in a high-growth suburban community that's got a lot of development pressures. And the planning you need for each. There we go. Hey, live again. Picking this up in the far reaches of Buncombe County. That's the back of this room. Thank you. The notion is that what is in your plan, what your plan is, how much effort you put into it, how elaborate it is, you should have considerable flexibility. The legislature can issue that. It specifies things that may be in a plan, future land uses and environment and affordable housing and the whole range of things you might want to consider. But what issues are important for your community and how you go about it is up to you. However, the one little tweak to that is that the plan, the actual adoption of the plan, you have to follow the same process you do for amending your zoning ordinance. So the plan adoption process, and this is new to our statute, says you need to send it to the planning board for review and comment. It needs to be approved by the governing board after a public hearing with a newspaper notice. And that applies to any plan that you're going to make mandatory for compliance with zoning and your other regulatory decisions. But exactly what's in the plan, how elaborate it is up to you and your jurisdiction. What you can't have, and the last point on plans, it has to be reasonably maintained. There was some discussion, should we have a 5-year update cycle, a 10-year update cycle, how old is too old? And rather than specify that, the legislation just says that's going to vary a lot. If you're a high-growth suburban community, a 10-year-old plan is close to worthless. If you're in a slow-growth, no-growth county, 10-year-old plan, not much may have changed in the past 10 years, and it may still be perfectly adequate. Maps. Your zoning map can be paper or digital. You do not have to have a paper copy. I was in a town a couple months ago that still had the official zoning map. Was this giant map with thumbtacks on the bulletin board in the council meeting room with each rezoning hand colored in. That was the official zoning map, and it stayed right there in the book. Very small town, not many amendments. The other end of the spectrum is to be completely digital in your GIS system, and the boundaries and the overlays in the GIS system become the official zoning map. You can do that if you wish. An important reminder, it is the clerk, the city clerk, must keep the official copy of the map, just like they keep the map, the zoning map, just like they keep the city boundary maps. A copy of your official zoning map needs to be on file with the city clerk at all times. And the city clerk really needs to keep your old maps, because occasionally a question will come up, well, what was the zoning of this property in 1989? And it's the duty of the clerk to keep all official copies of the map, including the old ones. And when you're adopting a new map, you don't throw the old one away. Somebody needs to keep that old official copy of the zoning map, even if it's only in digital format. The big innovation in the mapping is that cities can now, 2022, incorporate by reference any map officially adopted by a state or federal agency, and may include not only the current map, but any updates to that map. And that will come, mostly is done to address flood hazard maps. So when the flood insurance rate map gets updated, a lot of locals use the flood insurance rate map to define their flood hazard areas. Sometimes it's a zoning district boundary. You put everything that's designated a certain way in the flood insurance rate map as a flood hazard overlay district, and have that as your standard. And when that gets amended, then you have to go back and amend your zoning map to be consistent with the new flood insurance rate map. What you'll be able to do going forward is just say the zoning, our flood hazard overlay district is as shown as the flood hazard area in the most recently approved flood insurance rate map. And you don't have to go back and amend your ordinance every time the firm gets updated. But you can also use it for the water supply watershed boundaries, ridge law boundary, or anything else, as long as a state or federal agency officially approves it. One of the things that I think is, does anybody still have conditional use districts? I mean, if you do, get ready to say goodbye to it. Conditional use districts were sort of unique to North Carolina, but it was a tool that was invented here in the 1980s as a way to get around what would otherwise be illegal contract zoning and illegal conditional zoning. And it said you can do a site-specific rezoning for an individual parcel and apply conditions to the development on that parcel. But you can only do it by using conditional use districts, where you put that property in a district that has no permitted uses. The only development that is allowed is with a special use permit or conditional use permit. And at the same time you put it in that zoning district, you process the special use permit, conditional use permit application. And you impose all your conditions on that permit. So you're concurrently doing a rezoning and a special use permit. As we talked about for 2 hours today, a quasi-judicial decision on a conditional use permit is a very different animal than a rezoning. And trying to do both those things at the same time for one project is close to impossible. It can be done, but it's challenging, it's difficult, and most every local government that did it wrong. This cleans that up to say, don't do that anymore. If you want to do purely legislative conditional zoning, you can. That's been allowed since 2005 in the statute. You can do that if you want to do a conditional use permit, special use permit, quasi-judicial. You can do that. Just don't do both things for the same project at the same time. And to clarify the terminology, the legislation says for the rezonings, call those conditional zoning and a conditional zoning district. Everybody uses that terminology for legislative rezoning. If you want to do it as a quasi-judicial decision, call it a special use permit. Do not call it a conditional use permit because it's very confusing if you've got a conditional use permit and conditional zoning that are very different and everybody gets confused with the terminology. So going forward, you can make this change now, but by 2021 you have to make the change. The legislative stuff, site-specific, is conditional zoning. Quasi-judicial is special use permit. Any old conditional use permit will be converted automatically to a special use permit. Any conditional use district rezoning you had will get converted to conditional zoning. You don't have to do anything. Law automatically converts it for you on January 1st, 2021. That will make life simpler in terms of just confusion among different places, calling things different, using different terminology, and people getting confused about it.
With respect to these map updates,
yes.
Do you see that being ripe for inverse condemnation claims?
A map update? Well, the fact that you can incorporate the map into the zoning doesn't change the legal consequences of that map, whether you did it automatically without notice and hearing or whether you did it after doing a rezoning process, whether it's an inverse condemnation, taking in the property without just compensation, is the substance. That's going to be the same no matter how the map gets adopted. So it doesn't doesn't make it any more or less an inverse condemnation. Now we've got most floodplain regulation is not going to be an inverse condemnation. The Supreme Court case we've got on that, the leading takings case is from Asheville, the responsible citizens case that said floodplain zoning, as long as there's some reasonable use that can be made of the practical use of the property at some reasonable value, it's not an unconstitutional thing. Conflict of interest standards changing a little bit. For legislative issues, the current standard is do not vote if there would be a direct, substantial, readily identifiable financial impact on you as a member. On a legislative or an advisory, if you're on the planning board, city council, county commission, and a legislative rezoning would have direct, substantial, readily identifiable financial interest, don't vote. That's been in the statute since 2005. You can, unlike quasi-judicial, in a legislative context, you can still participate in the deliberation. If I'm a city council member and you're rezoning my property and that rezoning is going to double the value of my property, I can still come to the hearing as a council member and say, I'm going to step around the table here, speak as a council member, yes, this is going to benefit me substantially, but it's a great thing for the community and I think it's a wonderful thing and I encourage you to vote for it. In a legislative context, that's perfectly legal. It might be bad politics, but it's perfectly legal. In a quasi-judicial context, no, I can't try to influence you as a decision maker. So that's the standard. What this new statute adds to that is you also must not vote if the application for a zoning text amendment or a rezoning petition, the owner of the property in a rezoning petition, you have a close family, business, or associational relationship with that person. So if a member of your immediate family is asking for a rezoning, you can't vote on it. A close family relationship is defined as a grandparent, parent, child, grandchild, sibling, including step and in-law relationships. Step, half, and in-law relationships. So that definition is added to the statute. So relatively, third cousin twice removed, vote. Your spouse, no. Even if you say, hey, it may have a significant financial impact on my spouse, but I can set that aside and I won't let that influence my vote. No. You might have been able to get away from this previously, not now. Yes, ma'am.
What's associational?
Associational. You're a member of the church that's applying for it.
My neighbor?
No. Think of an association. You're both, it's the Elks Club that's applying to improve their lodge, and you're a member of the Elks Club.
Okay, okay.
So you're a member of First Baptist, and First Baptist is seeking the approval.
Okay.
Close business relationship, the fact that you do business with this person, you shop in their store, no. They're your accountant that's been doing your taxes for the last 20 years and know all your financial secrets, yes. That's a close business relationship.
What about somebody who's in the same homeowners association?
HOA, probably not, I wouldn't think. Although, I'd be more careful about this as a practical matter and a quasi-judicial matter than I would a legislative matter. I think, although the wording may be the same, I think is a more demanding standard when you get to quasi-judicial. We had a case that went to the Court of Appeals just this past year. City was doing a special use permit, quasi-judicial, for a very controversial project in town. Neighbors opposed it. This was adding a truck stop near the interstate adjacent to a residential neighborhood. Big truck stop. Prior to special use permit, neighbors strongly opposed. Went to the city council, and I think initially they approved it, and the neighbors challenged it, or maybe they denied it, and the applicant, I forget which way it went the first time around. Goes up to Court of Appeals. They send it back and say, oh, messed up the stuff we talked about earlier. Redo this decision. There's not enough evidence to say whether it should have been issued or denied. We want you to hold another hearing and redo the decision. In between decision A and decision B, the person who had as a neighbor, strongly opposed the project, had been an officer in the homeowners association that opposed this, had donated money to create a website opposing the truck stop. As a result of their citizen activism, they said, this government stuff's more interesting than I thought. This zoning stuff might be fun. I'm going to run for city council. I get elected to city council. And lo and behold, what comes up before the city council? A special use permit for a truck stop. I haven't said a word about the truck stop since I got elected to city council. Can I vote on the truck stop special use permit? It's been a fun case. The member said, hey, I'm a citizen. Don't you want to encourage citizen activism and participation and engagement? And the fact that led me to elected office? Isn't that a good thing? And the court said, well, that's a good thing, and we want to be careful about stifling engagement. But this is a quasi-judicial matter. It is not just any truck. You didn't run as an opponent of truck stops generically. You opposed this specific project on this parcel and were an active participant as an officer of the Homeowners Association, as a vocal proponent, you contributed money. You're biased, you can't participate in this decision. And I think that's an illustration of the sort of more demanding inquiry that if it were a legislative decision, that sort of active engagement is probably okay, but once you get to quasi-judicial, the courts are more demanding. And I think the same is true for associational and these other relationships.
How about a fellow board?
A fellow board member? I wouldn't think that's an disqualifying associational relationship. I don't think so. Now, the board member themselves shouldn't, but other members, if you were, there's a different statute in New Jersey, but we're not in New Jersey. There is a case exactly on that in New Jersey, but in the interest of time, we won't talk about New Jersey land. Plan consistency. This was something that I thought was, how complicated can this be? This was added to the statutes in 2025. Our legislature talked about, should we, like some other states, require that zoning decisions be consistent with the comprehensive plan? We said no, just consider it. But the simplifying plan consistency statement is something this new statute does. It just says, do this in a single motion. If you talk about plan consistency, that's enough. It's helpful if you adopt this statement. And if you adopt a zoning that's inconsistent with the plan, what it does is amends the future land use map in your plan. Simplifies that a lot. We already talked about the terminology. For boards, what is, we had the question earlier, is the spirit of purpose quasi-judicial? Once it says yes, it says apply the same quasi-judicial standards you do for everything. It's one set of quasi-judicial procedures for all quasi-judicial decisions, no matter what board is doing it, no matter what type of decision in terms of applications, etc. The meeting packet explicitly allows that. You can send out a meeting packet ahead of time. The application supporting materials to the board, but you need to send it to the applicant at the same time, so the applicant gets that. And when you get to the hearing, you introduce that as an official part of the hearing record. And if you haven't mailed it out ahead of time, the application reports all become, you have to introduce those as an exhibit as part of the hearing record. Historic Preservation Commissions. We have an odd provision in our Historic Preservation statute. Unlike all quasi-judicial decisions except a certificate of appropriateness, if you don't like the decision, you appeal it to Superior Court. You don't like the Board of Adjustment's decision, Housing Appeals Board, you go to Superior Court. Since the Historic Preservation Statute was written in the 70s, it's had a provision that says before you go to court, you have to go to the Board of Adjustment. So you have a certificate of appropriateness, you go from, if you don't like it, you go to the Board of Adjustment, and then you go on to court. The problem is the Board of Adjustment, what are you taking to the Board of Adjustment? They're not supposed to take any new evidence. They're acting as an appellate body. They're not supposed to second guess the substantive judgment of the Historic Preservation Commission. After all, they don't have any special, is this congruity or not? Is not something they have any expertise to decide. What they should be looking at is there substantial competent material evidence in the record, which are all legal questions, and they're not particularly well equipped to do those things. So, the new statute says the default is you go directly from the Historic Commission to Superior Court, just like all other quasi-judicial. And if a local government wants to put in an appeal to the Board of Adjustment, they can, but you have to add that to your ordinance. The default will be you go directly to court like everybody else. I think that's probably a good thing, but each local government can decide for itself if it wants to go to the BOA or not. A few other very quick minor things. Once a city adopts ETJ, which still exists in many parts of the state, some jurisdictions have had less ETJ than others.
What is ETJ?
ETJ is extraterritorial jurisdiction. In 1959, all cities in North Carolina were given the authority to extend their development regulations to a perimeter area around the city, 1 to 3 miles based on the population of the city. and they apply zoning, subdivision, housing code. And once a city establishes extraterritorial jurisdiction, the county loses all of its jurisdiction for any development regulation in the ETJ. It goes over exclusively to the city. The legislature can decide that certain cities should not have extraterritorial jurisdiction. If you happen to be Asheville or Weaverville or Boone, you have learned that lesson recently. But assuming you still have it, the county loses its jurisdiction. The problem is the city does not have to extend all of its regulations to the ETJ, so the county loses its authority. So you have the situation that the city might have a housing code that only apply internally to the city limits, and the county has a housing code, but at the ETJ, the county has no authority to apply its housing code in the ETJ. This legislation just says, new legislation says, if the city is not exercising a particular type of development regulation in the ETJ, the county has the authority to do it in the ETJ in the absence of city regulation. It also specifically allows you to accept an application pending a change in jurisdiction. We're about to get annexed, we're deleting the ETJ, it's going to be in the city or county jurisdiction. You can accept an application, take a fee, deposit the check, hold your hearing, do everything except make a decision prior to the shift in jurisdiction. So you can, for example, vote on annexation and zoning the area and issuing a special use permit all on the same day. You can do these things in anticipation of shift of jurisdiction. A new staff conflict of interest standard that applies some of the same standards that apply to the boards, the staff. Staff doesn't make a decision on if they would have a financial impact or a close family business association relationship with the applicant. You assign it to another staff member. If there's not another staff member, it goes to the manager. Minor modifications to existing permits you can do. Last mention of other things before I slip into affordable housing. There's some other things that were done in 2019 that are notable. One of them is you can no longer have, and this is already effective, not 2021, but today, you cannot have third-party down zoning, which is to say that if I want to change the zoning of property to reduce the uses allowed or to decrease the density of that development, I cannot ask you to rezone somebody else's property to accomplish that. Down zoning, decreasing the density, decreasing the uses, can be requested by the owner. It can be initiated by the unit of government. The city can downzone something over the owner's objection. It can be initiated by the planning board, but it cannot be initiated by a third party, somebody else other than the owner or the unit of government. Right. Now, if I want my neighbor's property downzoned, I can go to the city council and say, I think you ought to downzone this. Would you initiate this? And if the city council agrees, they can proceed ahead. But I can't start the ball rolling with the notice and hearing myself. I have to get the city to do it on my behalf. As a practical matter, if I can't get a city council member to at least initiate it, I probably won't even get them to adopt it in the long run anyway. So I don't know if this makes that much of a practical difference, but it is a difference. And also, if you're doing conditional zoning, you need to get the landowner's consent in writing to the conditions. Now, the statute has always said you can only impose conditions with the consent, but this specifies that you need to get that consent in writing up front. I think that's everything I had on the changes.
In writing up front, so sometimes as you're going along with P&Z, you've got the conditions, you say to the applicant, do you agree with these conditions? You have them written. And the final one will have to be written. So at what point are they just verbalizing, they're saying, yes, I agree with those conditions?
Yeah, I think you got some latitude in the mechanics of that, but I would, I'd be cautious and try to get, once you've got that list finalized and before the city council votes on it, I say at that point, would you sign this piece of paper and get their signature at that point? I suppose you could get it in written consent afterwards, but then what happens if you adopt it and the person says, well, on further reflection, I'm not signing that. Then you got a mess. All right, affordable housing. Affordable housing, big issue, has been a while. There are housing, particularly in a place like Asheville, resort areas, is expensive, it's difficult, it's hard for people to afford to live in places. There's some interest in a few jurisdictions around the state to address this by legislation and by local ordinance in terms of regulatory requirements. My hometown, Chapel Hill, for example, has for 20 years said we are not going to rezone property for new developments unless that new development agrees to include at least 20% affordable housing within the development. So if you want a rezoning from single family to multifamily, or from single family to a new redevelopment, mixed use development, we would like to see 20% affordable housing. Does the town of Chapel have the statutory authority to do that? Probably not. Almost certainly not. It is not explicit, certainly in the statute. I've worked enough with our legislature to know if you took that to them and asked them to give you that authority, they would say, what? You're even thinking about doing this? I think it highly unlikely you would be granted that authority. Who knows? Until you ask, you never know. Chapel Hill has not asked. And they don't do it, they do it somewhat indirectly. The ordinance doesn't explicitly require a 20% affordable. What it says is we will only rezone things that are consistent with our comprehensive plan. And our comprehensive plan has a goal in it that all new development will have a full range of affordability, and that full range of affordability will include at least 20% of the housing available to people with a median income of 60% or less of, and so forth. And Chapel is quite good about saying, hey, develop your property. If you want to develop this in single-family homes on an acre, have at it. If you would like this more intense development, would be a lot more favorably inclined to consider this if it's consistent with the goals in our plan. Here are the goals in our plans. And so far, for 20 years, most all the developers in town have said, fine, we'll be glad to do that. We think that's a laudable goal. It's a good idea, and we can make a boatload of money anyway. And they've gone along with it. And there are only about half a dozen jurisdictions in the state who have tried to do that through mandatory inclusionary zoning that's referred to. And their statutory authority to do that is thin at best, and that's being charitable. So a lot of attention is focused more on, well, what can we do, not through a regulatory mandate, but with incentives, providing grants, providing funding, and for decades you can build public housing. You certainly have the authority to build public housing, a lot of that done in the 50s and 60s. But what can you do to engage nonprofits in the private sector in the provision of affordable housing? And can you give some incentives and some encouragement to folks to do that? In terms of incentives, in terms of, for example, density bonuses, can you say if you do affordable housing, we'll give you 20% more density or 30% more density? Again, the statute is not clear whether you can do that. We have explicit incentives for energy efficiency, but not for affordability. We talked about adding that in 160D. The development community said, we prefer you not include it. There will not be consensus if you want to add that. So that's not added. But it doesn't say you cannot do it. And some jurisdictions have gotten local bills to allow them to do it. Some have just done it, incentives, density incentives and the like. They haven't proven to be particularly effective in practice. Most developers have not really taken advantage of those incentives. And it hasn't had much of a track record of actually producing affordable housing on the ground. What has worked reasonably well is providing money, either incentives of various sorts. Two things you have to worry about if you're providing grants, financial assistance to people doing affordable housing. One, if there's a constitutional limitation. You can't give away public money to private parties, even for a laudable sort of thing. You can't say, you know, the Boy Scouts are good, let's give money to the Boy Scouts. What you can do is provide financial assistance if it is serving a public purpose. You can only use tax dollars to assist if it is serving a public purpose. And our courts have said provision of affordable housing is a legitimate public purpose. So the constitutional hurdle is one that local governments can get over. It is not unconstitutional to provide public funding to assist in the provision of affordable housing. But we have some statutory limits. And those statutory limits do kick in and can get fairly complicated. The statutory limits say if you're giving these grants, at least 20% of the development has to be affordable. And there's a definition of affordable that gets into the average median income for moderate income and low income, and those statutory definitions are there. You have to assure that that housing is going to be available for affordable housing for at least 15 years. And that gets into the maintenance of affordability, so you don't want to give a grant to somebody, they provide affordable housing, and then that person gets a windfall by selling it 5 years later to somebody no longer affordable. So you've got to do maintenance of affordability and ensure that they remain affordable, either the rents or the sales price, for at least 15 years after the project is done. Counties have a little more flexibility than cities do in this respect. So some of these set-aside provisions technically do not apply to the county, while they do apply to the city. But the county is still going to be subject to that constitutional limitation, and that constitutional limitation is going to have something akin to that. You've got to make sure that it's really affordable, has maintenance of affordability, and so forth. So that statutory limit, even though it may not technically apply, or the counties may have a workaround, it's still going to limit what you do. So, based on that authority, some local governments around the state are doing some significant investments in affordable housing and working with nonprofits, be it waiver of fees for application fees, provision of infrastructure, subsidies to help build the development for both nonprofits and for-profit groups that are dedicating at least some of the 20% of the projects to affordability. But it starts getting complicated. A lot of these, the most successful ones around the state, generally involve some detailed working relationships with things like community housing trust funds, to do maintenance of nonprofits like Habitat and others who are engaged in this on an ongoing basis. But there is a lot of flexibility there, and if it's an important issue for your community, there are opportunities, probably more opportunities in the sense of using public funding to assist the creation of new affordable housing than there are to do it through a regulatory approach. That's affordable housing. Be glad that we've got all of 6 minutes to entertain questions, thoughts, observations on anything here and there. Yes, sir.
What makes it affordable? The price or the size?
The price, the sales price or the rent.
So if I'm on townhouse county, so we say, we'd like you to have 20% of the work, and we'll resell it for it.
Right.
And we have the statutory say, you mentioned the windfalls, we say, first of all, the property tax is going to be, so you're lowering the price, but at some point, property tax should come up to your neighbors, same size house, I guess.
Right.
How do you prevent them from reselling? So the developer says, I'm going to sell 20% of them, I'm going to give 20% away for free. I'm going to really make it.
Right.
And the homeowner sells it here. Now it's not affordable.
And you don't want a one-time affordability, you want a long-term maintenance affordability. And that is challenging. And that's why I say it's often easier to work with a community housing trust, and they will own the property, and they'll sell it, and they'll have some covenants.
They'll have covenants or
And covenants and rights of first refusal, and you can do it, but it does take some folks who work with that, and it can be challenging administratively, but it is manageable. But defining affordability, there are statutory definitions, usually based on percentage of average median income for the region, and 60%, 80%, different levels of low income, moderate income, and then based on what percentage of their income they're devoting to their housing costs. So you're not paying more than X percent of your income for housing, is what makes it affordable.
Going back to the quasi-judicial part of the discussion.
Yeah.
Talk about the role of staff in formulating recommendations, providing information, evidence for variances and conditional use permits.
Quasi-judicial role of staff in preparing information and materials. The statutes are silent about this. The new statute says you can do it, but the current statute don't say much about it. Staff generally has a critical role in sort of managing the process in terms of crafting the application, working with the applicants to educate the applicants as to what they need to help educate the neighbors as to how they can effectively participate. The staff plays that kind of informal role. In terms of relationship to the board, typically the staff is going to compile all the materials, get them together, manage them, package them up, get them to you to review. Typically, I'd say 90% of the jurisdictions ask the staff to do a staff analysis as well. So the staff will do, you have some staff that has some expertise, and they will look at the application, and they will give you the information. What does the plan say about this? How does it meet the ordinance requirements? Some analysis that applies their technical expertise to the issue, and they submit that. If it becomes a part of your record, you need to have a staff member that prepared that come to the hearing. The staff member gets sworn in like any other witness and answers any questions about the material. Often explains it, says here's a summary of my material. You happen to answer any questions about it. If it's an appeal of a staff interpretation, the statute requires that the staff member who made the interpretation be present as a witness at the hearing to explain what they did and answer questions about it. Whether you go so far as to ask the staff to give you a recommendation as to the outcome, that's entirely up to you. There are a lot of boards that say, we want the staff to give us analysis, but don't tell us what our recommendation should be. There are other boards that say, hey, we're paying you good money. We want your recommendation. We may not follow it, but we'd like to know in your professional judgment what you think we ought to do about this. That's up to each board as to whether you want to ask for a recommendation or not. I worked for 10 years with a staff that always gave a recommendation. And one of the reasons I'm familiar with draft, we would always not only give a recommendation, we would prepare a draft decision and say, based on the evidence you're about to receive, your conclusion is going to be A, B, and C, and here's where you can sign at the bottom. But we were also very, I exaggerate a little bit, but not much. But we were always very careful to say, only sign this if you think the evidence that you actually received supports this and you agree with it, and feel free to amend it in any way you think it needs to be amended to reflect the judgment of the majority of the board. But if you want to say that's going too far, we don't want a draft decision, we don't want a recommendation, we just want the analysis, that's fine. But that's a board decision as to what the board would like to ask the staff to do for them. And I think there are pros and cons for both ways. I can tell you, a lot of folks believe the staff has undue influence. People particularly who get a decision that the staff recommends that they don't like, they will be grumbling about the staff leading the board around by the nose and the board just rubber stamping whatever the staff recommends. I've worked with enough boards to know that's rarely true. That if you do really good staff work, it's complete and it reflects what the board wants, and they use it, that's a good thing. But I would be mindful of that perception and be careful about that, and make sure that the board itself actually makes these decisions and determinations. That said, we're at the end of our time. I'll be around for a while if I want to chat about any of these things in more detail today or later. I'll be glad to do that. Our contact information in the handout you got. Thanks a lot.